Hello, everyone, and welcome to Uncivil Law. We are doing our weekly recording session as always. So I hope you're having a good day. And I did notice in prior live streams that there was a very slight offset between the video and the audio. So I've attempted to adjust that so people can let me know whether or not my words are in fact syncing with the sound a little bit better. I mean, we were talking like a couple frames, so it was really, really hard to see. But if you really, really paid attention, there was a little bit of offset. So I added in a little artificial offset. So hopefully the words and the movement of my mouth are more in sync than they were before. So someone can let me know if that's actually working. And if not, well, I'll change it back, I guess, or something. But that is, that is our technical aspect for the day. Very exciting. All right. So we are here with our recording session. So let us discuss the stories that we will be discussing today. We are going to be discussing with a case dealing with an attorney who was being really obnoxious in an attorney's fees case. So, yeah, it makes thinking easier, yeah. Someone can let me know. But I'm definitely not doing that all session long. So either it's okay or it's not. And if it's not okay, then I'm just changing it back. I'm not screwing around with it. All right, and then we got a case dealing with a person who was adjudicated mentally defective. The video is like a quarter second ahead of the audio. Okay, so I'm just going to cut it off completely. I'm not screwing around with this, so I'm just going to change it back to 0. I'm not doing the clapping thing over and over and over. I'm not chasing down that rabbit hole. So I'm just going to change it to 0. So screw all you guys. I'm not chasing the rabbit hole of clapping and manually tweaking it. Whenever we do the editing to post it, when this is only a problem for live. It's only a problem for the live stuff because when we do stuff that isn't live, we edit it from the original video recorded to disk. So it's not wrong on the stuff we post that's cut up. It's only a problem live. But I added in an offset and the offset was wrong, and I'm just changing the offset back to 0. I'm not screwing with it all day and chasing clapping. I'm not doing that. We got an issue with a person who was adjudicated mentally defective and was prohibited from buying firearms, and so we'll deal with that. We got an issue with a person who, police officer who solicited favors from the girlfriend of a suspect in order to not charge that suspect. So we're going to be doing that case. We got a case dealing with a person who was shot by the police for apparently not doing anything and whether or not that's okay. We got a case dealing with a probation company that's trying to get some sort of qualified immunity or other immunity for stuff they're doing. We got a case dealing with a person whose money was seized by the TSA. So we got one of those great cases, USA versus $39,000 of currency. So we're going to be discussing USA versus $39,000 of currency. Good stuff. We got a case dealing with a person who was pepper sprayed or chemically sprayed by a prison guard, and whether or not that was okay. We got a case dealing with a Title IX situation and whether or not the university did enough to protect a female who was being harassed by a fellow classmate. So we're going to be reviewing that. Hello, Chief Beats Big Stick. Hi from South Carolina. I recently was in South Carolina, of course. That was I don't know if I ever made that clear, but all that stuff that was in that really empty room, that was all recorded in South Carolina. So, that was, I enjoyed being there recently. And then we're going back in time because someone had requested it at one point, and I'm finally getting around to it. We're going 1978. Johnson versus tax commissioner from the tax court, whether or not people can be required to pay income tax or not, or whether or not, people don't have to pay income tax. So we're going to read a decision from the tax court in 1978 as to whether or not people can be forced to pay income tax. So, yeah, we're doing that. So that is our stories for today. For those of you who didn't see the live stream yesterday, where I did part 2 of Stupid Letter Time, I recommend it. I'm going to be cutting 2 excerpts from that and also posting that as daily videos. So that's 2 more daily videos because I did a pretty lengthy discussion on on Citizens United, and I did a pretty lengthy discussion on why the gerrymandering decisions had to come out the way they did, or the rationale for why they came out the way they did. So let's just start with going back in time. No, that would be the 16th Amendment, Nicholas Rizzo. The 16th Amendment is the income tax amendment. It's going to come up. And so, speaking of which, let's just do that case first. So I'll do my standard introduction, and we'll get started. And also, I've changed the OBS window and where it is, and changed things to try to look a little bit more directly into the camera. I've also changed my camera to be a little bit bigger. So, we continue to experiment with things to make things a little bit more approachable. So you get to enjoy this much bigger shot of Uncle Blackleaf. Very exciting. Yeah. Hello, everyone, and welcome to One Civil Law. For today's case, we're going back in time. This is a 1978 case from the United States Tax Court. This is the case of Philip Johnson versus the Commissioner for the IRS. In this case, Mr. Johnson doesn't think that he should have to pay income tax. And so he's raising a bunch of objections as to why the income tax law is unconstitutional or illegal or otherwise not applicable to him. So he's a tax denier. So we're going back in time to read some of the rationales as to whether or not you have to pay income tax. So we're going back to some of these foundational cases. Someone had requested it. We had to get around to it sometime. So let's get started with this. Respondent determined a deficiency of $724 in petitioner's federal income tax for the year 1974. As someone who at the time of this recording is currently trying to do his taxes, I suppose this is a pertinent and timely issue for us. Can I be forced to pay income tax? Let's find out. The deficiency arose from respondent's disallowance for lack of adequate substantiation of certain portion of deductions claimed to have been paid or incurred by the petitioner in 1974 for real estate taxes, charitable contributions, and other miscellaneous expenses. So in other words, he tried to deduct things, and the person at the IRS said, you didn't provide enough proof that this actually happened, so you don't get to do these allowances. So you owe us another $724. Okay. At trial, petitioner declined to present substantiating evidence with respect to the item, although the court repeatedly urged them to do so. Instead, so we got a female tax denier here, she chose to base her case on several constitutional challenges to the federal income tax law and its specific application to her. Good luck. She also attempted to withdraw without prejudice her petition in this court, presumably to file a complaint in the federal district court. So one of the things you can do in terms of like where things are being filed, like if one of the things that's being issued is the tax that's due, you can bring that before the tax court, which deals with taxes, and you might be able to also bring that in federal district court, right? So you might have your choice of venue depending on the circumstances. And you filed in one place, and you now may be filed in a different place. So does the court have to let you do that? No, but they're going to explain why. Although petitioner's allegations do not easily lend themselves to precise and concise restatement, in other words, they're a jumbled mess of unclarity, but we, the court, are going to do our best to try to figure out what you meant to say. Despite your efforts, we are going to try to figure out what you meant to say and give you full faith to that. So we're going to give it a shot. Her constitutional challenges are as follows. The federal income tax statute is unconstitutional, having no foundation in the 16th Amendment. Well, since the 16th Amendment is directly about taxing authority, good luck with that argument on the federal tax has no basis in the 16th Amendment. That should be entertaining. Respondent's determination of deficiency was not only an impermissible bill of attainder, which, by the way, a bill of attainder is when a legislature passes a law that says you're guilty of something criminally. That's a bill of attainder. When they just pass a law that says you are guilty, like flat out, you're actually guilty of the crime in question. You're just guilty. That's a bill of attainder. So apparently, this is a bill of attainder. Okay. It was also arbitrary and violation of the First Amendment right to petition for government of redress of grievances. How? How was it a violation of those things? The Fourth Amendment to be free from unreasonable searches and seizures, and Fifth Amendment due process rights. No, you're getting due process as we speak because you're before a court, so that's not a thing. Placing burden of proof upon petitioner in the process violates the Fifth Amendment right against self-incrimination and other constitutional provisions. No, we want you to show your work. You don't think you should have to pay taxes. We'd like to have some evidence of it. For example, some receipts of your charitable gifting or something would be nice. Nice to have to show that you actually did these things. Please provide us evidence that you did this so we can adjust your taxes. You don't want to tell us about it, so, we can't consider it. But you're going to say it's a Fifth Amendment issue. Sure. In this case, was in contravention of our Sixth Amendment right to counsel. No, because it's not criminal. And Seventh Amendment right to a jury trial. No, because it's, no. And this may be my personal favorite / least favorite part of it. The federal income tax placed petitioners in condition of involuntary servitude in violation of the 13th Amendment. So the 13th Amendment, for those of you who are remembering, is the one that prohibits slavery. So it's the 13th Amendment makes the income tax illegal, even though the 16th Amendment explicitly talks about the income tax. So, that isn't an overreach in any way. Okay, good. Before addressing the substantive arguments, there's actually substantive arguments. Oh, well. We state at the outset we must deny the motion to dismiss, which is an attempt to withdraw the petition without prejudice. The jurisdiction of this court is invoked when a taxpayer who has a statutory notice of deficiency files a timely petition with the court to redetermine such deficiency. So remember, one of their complaints was, hey, you denied me my right to petition for redress of grievances. Well, the court is saying no, not so much. Not only did we deny it, you specifically asked us for it, and we're giving it to you as we speak, literally right now. So you filed a petition for redress with this court. We are now considering your petition. So how can we deny your petition when we're actually considering as we speak right now? I don't know how this is happening, though. Once invoked, the jurisdiction of the court is exclusive with respect to the years included. So if you bring it before the tax court, we're the only one who can consider this issue. Fair enough. Moreover, if the court dismisses a case after petition is filed for any reason other than lack of jurisdiction, a decision must be entered as to the amount of deficiency. So even if we deny your case, we have to say what the amount due is. And that makes sense, right? We have to provide notice as to how much you owe. Consequently, even if we were to grant the motion, not only would a subsequent suit in the federal district court be barred, but our dismissal would operate as an adjudication on the merits. So the district court is saying, okay, if we actually do what you're asking us to do, you'd actually be more hosed than you would otherwise. You can't see what's going to happen, so let us just try to calmly explain to you what's going to happen if we do this. Once our jurisdiction is invoked, we're the only ones who can do this. So as a result of that, the district court no longer has jurisdiction. They might have had jurisdiction in the first instance, maybe, but you invoked our jurisdiction. And so once that's done, it's done. And now we're the only one who has jurisdiction. So you can't go flee off the district court now, because we're the only ones who have jurisdiction because you asked for it. This is a consequence of asking for stuff. Sometimes you actually get it. So now we have jurisdiction. So if we were to do this, if we were to grant your motion, you wouldn't be able to file in district court because we're the only ones. Also, because we did it because you asked, you couldn't file here because we dismissed it because you asked, and you'd have an adjudication on the merits. So you'd actually be worse off if we granted it to you because you'd have no claim of relief anywhere. So us, being super, super nice, are not only going to try to interpret your petition to figure out what it is you meant to say, despite your best efforts of your garbled nonsense, we're going to try to figure out what it meant to say. We're also, in the effort of being super, super nice, not going to grant your motion to dismiss because you can't see it would actually screw you. So we're going to prevent you from harming yourself, and we're going to figure out what your petition meant and figure out whether or not you have a claim of relief. We're just being really, really super nice. We are saving you in spite of yourselves. That's how nice we're being. We are a nice court. According to the petitioner, the framers of the 16th Amendment envisioned an indirect excise tax on corporations, such as that contained in the Tariff Act of 1909. Since petitioner is, and here are the magic words, since petitioner is an individual sovereign citizen, check, and the federal income tax is direct progressive, she claims she's not subject to the tax. No. Although petitioner's sincerity and devotion to the principle cannot be gainsaid, in other words, we're not going to evaluate whether or not you actually believe this. We're not going to try to crawl into the depths of your mind and try to figure out whether or not you actually believe this stuff or just saying it. So we're not going to try to undo that riddle. So we'll just take it for granted you actually believe this. The constitutional challenge to the federal income tax must be rejected. No, you don't say. The constitutionality of federal income tax passed since the enactment of the 16th Amendment has been upheld judicially on too many occasions for us presently to rethink the underlying validity thereof. See example, bunch O cases. Furthermore, the 16th Amendment was enacted in response to the Supreme Court's decision in Pollock, which held unconstitutional the income tax of 1894 as a direct tax without apportionment. So in the original Constitution, as it was originally drafted, you had two different kinds of taxes. You have direct taxes and you have indirect taxes. The Constitution, as originally drafted, said that if you're going to do a direct tax, it has to be done with apportionment. So among other things, one of the things you'd have to do is you'd have to make sure it's even as to citizenship. So you'd have to make sure everyone is equally impacted. You'd have to look at citizenship data into the things. And so under this 1894 case, they said, well, this tax you're trying to do is a direct tax because it's an income tax. Again, under the Constitution as it originally existed, that would be a direct tax because it's directly to you as an individual. That is what we mean by a direct tax, as opposed to an indirect tax where it's like tax not directly on you, but as something incidental to something else. So like a sales tax is probably not a direct tax. It's probably an indirect tax, because it's not directly against you. An income tax is directly against you. We're taxing it directly as you get the money, not incidentally to something else. So the 1894 case said, well, if you're going to do that, it has to be apportioned. Okay, well, the Constitution was changed. That was the entire point of the 16th Amendment. So the 16th Amendment says explicitly that you no longer have to do apportionment to solve that issue. So now, under both a direct tax and an indirect tax, it does not have to be done with apportionment. That was the entire point of the 16th Amendment, is to remove that requirement. It was a requirement of the original Constitution, but someone proposed a change and it got ratified. And so, well, now that's the Constitution now. So now it doesn't have to be done with apportionment because the Constitution's been changed. That was the entire point. Thus, since the ratification of the 16th Amendment is immaterial with respect to income taxes, whether it's a direct tax or indirect tax, we no longer have to figure out that question, right? We don't even have to ask the question if an income tax is a direct tax. In my explanation I just said just now, I said it was a direct tax, but I suppose you could quibble with that. You could say, no, it's actually an indirect tax. And so we could actually have an argument. Is it an indirect tax or direct tax? Now, personally, I'd say it's a direct tax, but I suppose we could have an argument about it. But the court just says we don't have to. We don't have to have an argument about it because it doesn't matter anymore if it's direct tax or indirect tax. Either way, the apportionment issue is irrelevant. So is it income tax, direct tax, or an indirect tax? We don't know. We don't care because it doesn't matter either way anymore. Okay, that makes sense. With regard to other constitutional claims, petitioner fares no better than she did with the principal challenge. Her contention that the respondent's notice of deficiency was an impermissible bill of attainder is without merit, not for the least of reasons that an executive agency can't do a bill of anything because they are not a legislature. An executive branch agency can't do a bill of anything. Only legislatures can do bills. I'm just a bill, only a bill, sitting here on Capitol Hill. So yeah, it cannot be the case that whatever the commissioner did was a bill of anything, because they can't do bills of anything, including bills of attainder. A bill of attainder, according to Black's Law Dictionary, every sovereign citizen's favorite dictionary, right, is a legislative act, right? We can just stop reading immediately. A legislative act. We can just stop reading. Because whatever the Commissioner of Tax is doing, it is not a legislative act. But we'll keep reading anyway. A legislative act directed against a designated person, pronouncing him guilty of an alleged crime, usually treason, but it could be any crime, without trial or conviction, according to a recognized rule of procedure, and passing sentence of death or attainder upon him. Attainder would just be any punishment. So as I said, a bill of attainder is a legislature passing a law declaring you guilty of something and sentencing you to such a thing. That's a bill of attainder. This is not that. Not for the least of reasons that, the taxing authority is not a legislative act, because it's not the legislature. You're in the wrong domain. So we could have just stopped reading after the first 3 words, but we finished the entire definition just for you. It is wholly irrelevant to speak of a bill of attainder in the civil proceeding involving tax liability. It sure is. Because the executive can't do a bill of anything at all under any circumstances, because they're not a legislature, yeah. It is clear that response deficiency determination was not arbitrary. Yeah, because it was, just general mechanistic application of law. We didn't do it to harm you personally. It did not violate your First, Fourth, or Fifth Amendment rights, citing law. The deficiency determination is presumptively correct, and petitioner has the burden of proving it's erroneous. The IRS does, in fact, make mistakes. They are just an organization like anyone else. They make mistakes, and if you can show that they're wrong by, providing evidence, then they're wrong. And courts rule against the IRS all the time. So for all the people out there who's saying, hey, a court isn't ruling against the IRS because they're afraid of getting audited or something, well, no, not so much. Courts rule against the IRS like all the time on all kinds of issues. They're not afraid of getting audited, and they don't care anyway, because the IRS ability to audit doesn't matter if you are paying all the taxes owed. Do I really care that much if the IRS audits me? Not really. I mean, it will be irritating and it will take time, so that's a little annoying. But at the end of the day, I don't really mind that much, because, there's not a whole lot to audit, and I've already paid all my taxes. And if somehow I didn't pay some of my taxes, it was due to a genuine oversight, so I'm not guilty of anything anyway. So I don't really care about an audit, because, the IRS doesn't have some sort of magic power over me. All they can do is say, okay, well, you failed and you should pay us some more money. And either they're right or not. So, a court isn't really afraid of them either. It's not like the IRS can just, do stuff. The contention that placing the burden of proof upon this case violates the Fifth Amendment privilege against self-incrimination is without substance. No, it doesn't. That's not what the Fifth Amendment had in mind. Neither does respondent given the court any reason to believe a criminal investigation is presently underway or even remotely possible. The sole purpose of the present case is to determine the existence, if any, of the federal tax liability, and accordingly, the general rule with respect to burden of proof in tax cases is appropriate. Right? So this is a civil case. It is a civil case at this point because it's not criminal, right? The issue we're trying to determine at this exact moment in time is your liability for tax, which is a civil issue. So we're under civil rules. And one of the things we can do with civil rules is burden shifting, right? Is burden shifting. So the IRS has the initial burden to show the deficiency, which they will do. And the way they'll do this is they'll say, well, here are the records you submitted, and these records are not valid because of here's some reasons. And so they have that initial burden. The IRS has the initial burden. And then it comes back to you. You have now a burden to show why the IRS is wrong. It says, no, IRS, you got it wrong because, here's some additional documentation, here's some additional evidence, here's some additional whatever, and you have to come back with some stuff. So burden shifting, not unusual, particularly in a civil case. It is not a constitutional violation. Not a problem. Neither petitioner's Sixth Amendment right to counsel nor the Seventh Amendment right to jury trial has been violated. The right to counsel extends only to criminal proceedings. Yes, it does. It's pretty clear it's only criminal. So if you're civil, you can provide your own lawyer, but one does not have to be provided to you. So it is inapplicable to this case, citing law. That's the law as much today as it ever been. Further, the petitioner was afforded a full opportunity to represent themselves at trial pursuant to law. There is no right to a jury trial in tax court and therefore does not violate the Seventh Amendment, because the right to a jury trial only existed to the extent it existed at the common law at the time, right? So the right to the jury trial is a pre-existing right. So when you're looking to see whether or not you have a right to a jury trial, even in a civil case, you'd look to see whether or not you had a right to a jury trial in the English law at the time. And you didn't have the right to a jury trial for this kind of civil issue. And also, like, the issues at hand are also legal, not factual. And also there is a right of redress to, like, arbitrariness as well. So no, you don't have a right to a jury trial because you never did. It was not within the scope of what the Seventh Amendment was talking about. So no. Petitioners claim that federal income tax places her in a position of involuntary servitude in contravention of the 13th Amendment is unsubstantial and without merit, and we're just not going to say anymore because it's that dumb. It is just that dumb. No, that was not what the 13th Amendment was talking about. It was not what the 13th Amendment was talking about on any level, right? The Constitution as it existed from square one had taxing authority. The authority of Congress to do taxes, and the authority of state to do taxes, was part of the reason the Constitution was created in the first place. One of the deficiencies of the Articles of Confederation was the inability of the federal government to lay a tax that was mandatory. They could vote for taxes, but they were optional. As a result, not a lot of people stayed, and not a lot of states paid. So one of the things the Articles of Confederation failed at was exactly this. One of the reasons the Constitution was created was to solve this problem. So taxes are no longer mandatory, or no longer optional. They're mandatory. And then there's like, okay, well, we put in the 13th Amendment that says you can't be held in slavery, but we also put in a 16th Amendment that says it wasn't meant to deal with taxes. The 13th Amendment did not have taxes in mind. It had slavery in mind. And, this is not that. And for you to say it is a little bit disingenuous and a little bit tone deaf with respect to what the 13th Amendment was trying to accomplish. So no, not so much. We reiterate the petitioner has the burden of proving the respondent's determination is erroneous. In our view, the rejection of the constitutional challenges to the federal income tax laws and refusal to present any evidence at trial substantiate the deductions. We have no alternative but to sustain the determination. Accordingly, we hold petitioners not entitled to deduct amounts paid by the 1974 real estate taxes, charitable contributions, and other miscellaneous expenses in the amounts previously allowed by respondent. Maybe if you had provided some evidence of some variety, maybe, but not so much. So you have to pay the taxes. So yeah. So that is the end of the 1978 case of Philip Johnson, or Phyllis Johnson, I should say. Phyllis Johnson versus Commissioner. In this case, we learned Phyllis didn't want to pay income taxes, and they appealed to the tax court. And the tax court said, but the 16th Amendment, though. And Phyllis said, but it wasn't meant to apply to this. It was only meant to apply to, like, corporate earnings or something. And, well, the plain text of the 16th Amendment doesn't say anything like even remotely close to that. It's pretty unlimited in its scope. It says that you can just have taxes and you don't have to be apportioned. So your idea that it only applies to corporate taxes or something is like, well, I don't know. We can all read, and the 16th Amendment doesn't say anything remotely close to that. So, no. And, this is not the 13th Amendment. This is not slavery, no. And you have to pay taxes. And you don't have a right to a jury trial. And you can invoke the Fifth Amendment, but, it can be held against you because this is a civil case, not criminal. So we can hold it against you. So, you didn't provide any evidence, so you have to pay taxes. So a sovereign citizen went to tax court in 1978. And in 1978, the court said, no, you have to pay taxes. And sovereign citizens have been trying ever since. But, not so much. This decision was completely right. And that's the end of this case. I look forward to the comments in the video when it posts from the sovereign citizens saying, because I've already seen a couple comments from sovereign citizens. I don't know if anyone else has noticed, but the sovereign citizens have poked up their head in my comments. So I look forward to the sovereign citizens telling me, no, I'm wrong and I'm part of the system and I'm a tool and haven't I read whatever and don't I realize about the money held in trust and the all caps and our true names and you as will surprise absolutely no one, I'm much more well read on the law than the sovereign citizens. So, yeah, good. But I do look forward to being law explained by the sovereign citizens. That should be entertaining. Don't you know the 16th Amendment was unconstitutional? Don't you know that? Don't you know that, unless they use your name in all caps, it's not your real name? And don't you know that because of the goldfinch flag that they don't have jurisdiction? And don't you know because the IRS secret bank account? And don't you know because of... Okay, well, I don't know which part of that to debunk first. I don't know which part of that to debunk first, but, the all caps thing, has absolutely no merit in law whatsoever on any level. It's a stylistic thing. It's just pure style. It has no legal significance of any variety to anything. So sometimes courts and or agencies will put your name all in caps. Sometimes they'll only put your last name in caps, but your first name in like regular. Sometimes they'll put the whole thing all caps. It's just stylistic. It is an arbitrary stylistic choice with absolutely no legal relevance of any kind whatsoever. So, they can put it all in caps. They can put your last name in caps. They can put, they could just do some sort of arbitrary capitalization. We're just going to arbitrarily decide at random points whether or not random letters should be capitalized for no reason other than we can. That'd be fine too. It's just a stylistic thing. Yeah. It's a stylistic thing. All right. Well, Courtney Grace asks, would I make a video about a girl from Texas whose parents never filed a birth certificate? So she's in a great area where she's born in the United States, but she's a citizen of nowhere. Well, Courtney, I will refer to my standing policy on these issues. My standing policy is in exchange for a $20 super chat, I will review a court decision. So if there's a court decision somewhere from a judge that discusses that for a $20 super chat, I will discuss it on the next stream. So I'll give you priority. Otherwise, it goes in my potential list of stories and will be reviewed at some point. I don't even know when someone suggested this 1978 case, but it definitely wasn't last week. It was like 8 months ago, someone suggested this case, and it's like, well, I finally got around to it. So for a $20 super chat, you can bump the line if there is a case, if there's a decision from a court for me to review. But long story short, the issue is, where was this person born, right? That's the issue. So if you were born in the United States, you're a citizen of the United States, birth certificate or no, right? You don't need a birth certificate to be a citizen. You need to be born in the United States to be a citizen. Now, the lack of a birth certificate makes proving that or establishing that a lot harder. But presumably what you'd do is you'd go to jury and you'd adjudicate it because it's a factual dispute. So you would sue the U.S. government and say, I'm a U.S. citizen, and they say there's no proof. And you'd argue whatever proof you have, any sort of documentation of any variety that would establish it. And then you could go to a jury trial and figure it out. Where were you born? So that's how that presumably would go. But if there's an actual decision somewhere, I'll analyze it. Yes, it actually has to be a decision of a court. It has to be a decision of the court because, I'm not going to say, why don't you cover this case that hasn't been decided? Because I've run into this problem already on the Vic Mignogna thing, right? I've run into this problem on the Vic Mignogna thing. If you ask me to cover a case that hasn't been decided, then the scope of that becomes so open because it's like, oh, I have to consider this pleading and that pleading and this deposition and that deposition, blah 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 blah. It's like it becomes much more extensive, right? So it's like, oh, why don't you just cover the case? Because the case might have 100 documents, might have 1,000 documents in it. No. If there's an actual decision, then sure, I'll analyze the decision. That is my rule, yes. So let us move on. Let's do the attorney's fees case. I'm not sure how much value we'll get out of it, but we'll try. I do use Fridays as a dump story day, because Friday is often called take out the trash day, because people don't pay as much attention to what happens on Fridays. So if a story winds up not being very good after I record it, well, it's probably going to be posted on a Friday. So this may wind up not being very good. It may be a take out the trash day. But hey, something has to be posted on Fridays. So, if it turns out to be bad, we'll see how it goes. So we'll see how it turns out. Yeah. I've already had way too much fun, and I use that word fun very loosely. I've already had way too much fun with the Vic Mignogna case. Because like I've read stuff and they're like, well, you didn't read this, you didn't read this, you didn't read this. I'm like, it never ends with these people. It never ends. Until I read everything, until I read all the things, and even then, probably I'm a tool, right? So it's like, well, I'm not making that mistake again. Not making that mistake again. Not making that mistake again. I'm only covering actual decisions where I can actually analyze it, where the court has already done all the work for me, and I don't have to dig into everything on 3 billion levels of depth, right? I don't want to do that in your average case. That if I ever choose to do that, it's because of me. It's because I want to do it. I'm not ever doing it on request. Probably no matter how much money someone gives me, because it's just a total pain in the ass. Like, what amount of money would you have to give me to actually have me dig into the entire Vic Mignogna file? What would make that worth my time? I mean, seriously, as an attorney, what would make that worth my time? Okay. It's going to be a big number. Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision in the case of Merrill Royce versus Michael Needle, the professional company. In this case, this deals a lot with attorney's fees and how much money an attorney is owed. And it is remarkable for its procedural aspect. This attorney really, really wanted to get paid. Really. So they fought for every last dollar for a really, really long time to what I would consider to be excessive amounts. So we're going to cover this case, and when an attorney really wants to squeeze every last dime out of this rock, could be exciting. Let's get started. This dispute over attorney's fees has a long and tortured history, not because it's unduly complex or involves novel legal issues, but because one of the attorneys, Michael Needle, protracted it every step of the way. He routinely and unapologetically tested the district court's patience, disregarded court orders, and caused unnecessary delays. As a result of the district court sanctioned Needle multiple times for obstructionist and vexatious tactics. This is not language you ever want to hear from a court. If you're being called even obstructionist isn't like as bad, but you use a word like vexatious, you're going to get my attention real quick. Real quick. The fee dispute arose only because of Needle steadfastly took an objectively frivolous position, and also frivolous is another word that will capture my attention. Some words, when they're used by courts, have particular effects that should cause an attorney to pay attention, right? So not all words courts use are created equal. One of these words that's not created equal is vexatious. That's a word that's not created equal. It's a word that causes an attorney to pop up and be like, what? What's happening now? What? You have my attention. Another one that really causes an attorney to pop up and pay attention is the word frivolous. That's another word that really causes you to say, what's happening now? Like that's a word where it's like if the court is saying that, you really want to stop and pay massive attention because bad things are about to happen. He and his co-counsel, Mr. Royce, were entitled to a lion's share, almost 60% of their client's settlement in an underlying suit as attorney's fees, which seems like a lot. But, like depending on the fee arrangement, depending on the situation, might not be completely outside the bounds, but it is on the high end. Even Royce, his co-counsel, that's nice, rejected Needle's position. So his co-lawyer said, no, you're wrong, and he's still going for it. Nice. Rejected Needle's position because the plain language of the contingency fee arrangement provided that the attorney's fees shall be 1/3 of the settlement, which sounds a lot more reasonable. 1/3. 60% is that's capturing my attention. 1/3 sounds a lot more reasonable. 40% even, it seems a lot more reasonable. 60% is like, no, ma'am. The district court found the same and then decided a sub-dispute over the division of the aggregate attorney fees between them under the separate co-counsel agreement. All right, so we basically have two agreements that are working in tandem. Okay, we have an agreement between the client and the attorney, all right, that says here's how much the client is going to pay. Fine, and we have an agreement between the attorney and another attorney as to like what their shares respectively will be. Now, this is legal, but you do have to like alert the client to it. So in the rules of ethics, if you are going to like give part of your money as an attorney to another attorney, you do have to notify the client of it. You have to notify them of this arrangement. So yeah, you can use the money to like give to another attorney, but you have to tell them. So like if you hire me and I say, well, I want to hire a lawyer, not necessarily one that already works for me. I want to hire a lawyer as co-counsel or whatever, right? I can do that, but I have to notify you that I'm doing that. Presumably because then you might want to fire me and just hire them directly. Presumably that's why I have to tell you, but I do have to tell you. So yeah. The court awarded Needle 60% and 40% of the aggregated fee. All right, so according to their agreement amongst themselves, the client's going to pay a third total, issue one, and then between you guys, your agreement is such that Needle gets 60 and Royce gets 40. Okay, if that's the agreement you reach, that's probably fine. And unlike the like fees due to the client, where the lawyer they're going to look at it like in terms of its reasonableness. So like if it was 60% total, we're like, whoa, wait a second, because that seems really high. Like the normal contingency is a third, 40%. Could I see 60% in some kind of case? Like maybe, but geez, that's really high. And we're going to look to its reasonableness and a whole bunch of other stuff. But as to the agreement between the attorneys, well, you're both attorneys, right? And you're not the client. So you can probably reach any agreement you want. 95-5, 50-50, whatever agreement you want, we're not going to get into it because it's not the issue, not the client, right? So if you want a 60-40 relationship, that's fine. So you want a 60-40. And Needle was saying, well, I'm entitled to 60% of the whole thing, not just a third, not just 60% of a third. So the argument is that 60% of a third or 60%. Obviously, those two numbers are pretty different. So we're going to go to the wall over this, I guess. At its core, it's a simple contract dispute. It sounds suspiciously like a simple contract dispute. Our retention agreement is a contract. We have a special name for it, retention agreement, but it's a contract, pretty much like any other contract. Although, as I mentioned, it does have some special ethical rules that don't apply to every other kind of contract. Like its objective reasonableness, because we're concerned about the client. So there are some modifiers as to this kind of contract that like wouldn't necessarily pop up in other cases. It became protracted, however, and developed into a 3.5-year row over with 1,000 docket entries. 1,000 docket entries. That's insane. That's 1,000. I mean, there's definitely been cases with a lot more than that for really complex litigation, but like 1,000 docket entries just to figure out what fees are due. In case you're curious, by the way, what a docket entry is, it's essentially, among other things, anytime a motion is filed or anytime a response is filed. So any like separate paper, right? Anytime a separate paper is being filed. So if it is and sometimes they can have attachments. So like you can do like a pleading that has exhibits. So that would still get one docket entry. But because it's a separate paper with attachments, the attachments count as part of the paper, right? But anytime you have a separate paper, it gets a different number. And also like my orders from the court and little judgments get there. So it's not necessarily just like documents that are filed. Usually sometimes it's like little notices, like seriously, they're like 2 sentences long, where it's like the conference hearing will be on this date, or the conference hearings has been moved to this courtroom, or like stuff like that. It can be really, really minute stuff, but for the most part, they're usually papers filed between the attorneys. So if you have 1,000 of these things, man, geez, oh Lord, over a fee dispute, you got to calm down, man. Many, if not most of them, were unrelated to the merits. That's just super exciting. Great. But how did this case come about? What is causing this complexity? This case stems from an underlying civil racketeering, influence, and corrupt organizations action. It's RICO. It's it's civil RICO. We're in this wonderful place because of RICO. Another reason judges don't like RICO. Yeah. Though not initially plaintiffs' counsel, Needle and 2 Illinois attorneys eventually came to represent them. The 2 Illinois attorneys would both later withdraw from the representation, which is never a super promising sign, because, among other reasons, they're trying to argue RICO, and it's not RICO, it's never RICO, so there's that. So Needle recruited another Illinois attorney to serve as co-counsel and local counsel Royce. Needle and Royce entered into a co-counsel agreement that set forth the division of attorney's fees received in the RICO action. Specifically, they agreed to split the half of any fee equally and made the other half proportional to time spent. Okay, this is a really kind of complicated agreement. But again, it's between attorneys, so complicated is allowed. So as to the total amount of attorney's fees, we agree as to half of it. We'll split that half equally. So in the total amount, that's 25%, right? So of the total amount of money, half of it will split equally. So that's 25-25, right? Okay. As to the other half, we're going to do it based on time cards. So you're going to get 25%, I'm going to get 25%, and as the remainder, we'll figure it out as we go. Okay. Together, Needle and Royce litigated the suit for several years, because RICO, before successfully settling the case in 2013. They actually managed to settle a RICO cause of action. They managed to get as far as settlement on a RICO, which, for anyone who knows anything about RICO, is not easy, because courts hate RICO and they will really drag you. So the fact you got to a settlement on a RICO, well, maybe it's because the other side got bored, but whatever it is, you got to a settlement, so good for you. Pursuant to a confidential settle agreement, which is not really that confidential because we're about to talk about it, the parties settled the action for $4.2 million. So according to the confidential settlement, you settled for $4.2 million. So that confidentiality, well, not so much anymore, but that's what we get to do because we're a court. Ha ha ha. $4.2 million on a RICO. I mean, that's good work. Importantly, sure, the settlement agreement provided for only a single lump sum of the $4.2 million, payable installments, without any further provisions related to attorney's fees, costs, expenses, or the like. All payments were made to Royce as an escrow. Okay, so the settlement said, we're going to pay you $4.2 million, end of discussion. Whereas it's not like we're going to say we're going to pay you this much for this much for this much for whatever. It's like, we are agreeing to pay you $4.2 million. We're going to pay you over this payment schedule. We want this in installments. But all we're saying is $4.2 million. That's the amount due. So it doesn't say anything about attorney's fees or costs or anything else. It just says, we're going to give you $4.2 million. Okay. Instead of bringing an end to the matter, which, it really should have, Needle was not happy with his cut. Needle just sounds like a great guy. He asserted that the attorneys, he and Royce, were entitled to a greater fee amount than Royce and the client group did. So, okay, he says they're entitled to more money than his co-counsel and the client does. So his own co-counsel disagrees with him. The client surely disagrees with him. So he's fighting both his co-counsel and the clients. He just sounds like a great guy. Specifically, Needle wanted $2.5 million, or approximately 60% of the settlement, leaving the plaintiffs and his clients with $1.7 million. That would be 60%, yes. You're going to get more than the client. It's, a little sketchy. Needle and Royce also disagreed over the appropriate division of the fees between themselves. The conflict froze the settlement proceedings in escrow, so Royce filed an interpleader action seeking a determination of the correct disbursements under the contingency fee and the co-counsel arrangement, which incidentally is ethically required in this situation. So if anyone is objecting over the amount, you have to freeze the amount in escrow to the degree it's being fought over. So not to any degree, but over to the degree fought over. So let me give you an example. Let's say that you build 10 hours and you think you're entitled to $400 an hour, which would be $4,000. And the client thinks you're entitled to $200, which would be $2,000, right? This is the hypothetical. And let's assume that there's $10,000 sitting in the bank account because the client paid you in advance. So the client gave you $10,000 in advance, all right? And now we're done. And the dispute is, well, I think I'm entitled to $400 an hour for 10 hours. So I think I'm entitled to $4,000. The client says, no, I think you're entitled to $200 an hour for 10 hours, so $2,000. What do you do? What do you do? This is a good one for all the law students out there, for all the law students out there who are saying under the rules of ethics, okay? So here's what you do in this situation. First of all, the maximum that under either one of your theories that anyone could possibly be entitled to is $4,000, right? That is the max. They think you're entitled to 2, but you think you're entitled to 4. So the upper limit of the argument is 4, right? So what you need to do, step one, what you need to do is you need to immediately cash a check for $6,000 to the client, right? Because that amount is not in dispute by anybody. That amount is not in dispute. They gave you $10,000 in advance. They think you're entitled to 2. You think you're entitled to 4. Well, $6,000 of this, no one thinks they're entitled to, right? Or neither the lawyer nor the client thinks the lawyer's entitled to it. It's the client's money. No one is disputing this. So what you need to do immediately is write a check for $6,000 to the client. That's what you need to do, step 1. Step 2, what you should do, probably in this situation, what you should do is you should write a $2,000 check to yourself because the money is sitting in an escrow account. Sometimes, it's sitting in a separate account that is distinct from your account because that's how attorneys do these things. It's called an ITAR account, usually. But it's held in trust, right? So it's not your money. So the money that's sitting in that account is not the attorney's money. It is held in escrow. But you can pay yourself $2,000. Why can you pay yourself $2,000? Because it's not in dispute. That's why. The money is owed to you. So you can't keep it in the ITAR account. You can't keep it in the ITAR account because the rules of ethics are clear that once the money is owed to you, we can't just keep it in the fund. So you have to disperse it, right? But that $2,000 is not in dispute, right? Even the client agrees that you should get at least that much. So what you should do, and after you write a check for $6,000 from the ITAR to the client, what you should do is you should write a $2,000 check from the ITAR to yourself, because even the client agrees that you're entitled to it. And then over the remaining $2,000 that's now sitting in the account, because that's the amount that's in dispute, right? The difference between $2,000 and $4,000. That's the amount that's in dispute. Otherwise known as $2,000. That amount that's in dispute, now you go fight about it in some way. So that's what you should do. Write a check to the client for $6,000, write a check to yourself for $2,000, and then argue about the $2,000. That's how you solve this problem. The rules of ethics are fairly clear on this. And so that's exactly what happened here, apparently, right? There's an amount that's in dispute, so we're going to freeze it in escrow while we figure all this out. Fair enough. The core of Needle's position, which underlies this entire litigation, was the attorney fee was separately negotiated during the RICO suit settlement negotiations and included a lump sum settlement amount, thus triggering subparagraph of A of the fee provision. Any fee paid to us pursuant to any settlement agreement. Fine. The district court expressed to Needle on at least 3 different occasions that it had serious concerns that Needle could present this claim consistent with the rules of Civil Procedure 11, which, requires you to have an actual cause of action. So the federal court 3 times says, I don't really think that this would be a viable cause of action. Needle did not heed the warning and continued to assert the claim. So they moved to dismiss and also for Rule 11 sanctions because it was a frivolous claim. Okay. The district court dismissed the count, asserting that the section governed the authority fee determination, finding that the arguments were not merely wrong, but frivolous, disregarding what anyone having taken a first-year contracts class could identify as pivotal legal issues, ouch, and utterly devoid of merit. This dismissal came with an award of sanctions, which is discussed later. It was like, wow, it's like, even a 1L would know that this is crap. Jeez, Lord. Following briefing on the motion to dismiss and the sanctions, Cariff D. Klobbs moves to withdraw as Needle's counsel. So, Needle, an attorney, as part of his fee dispute, has hired an attorney, which I suppose is a good thing to do. Attorneys need attorneys too. So he's hired an attorney to say, hey, I'm entitled to more money. And this person represented them for a while. And then there was then like some stuff happened, and then they said, I don't want to represent you anymore because this has gotten to the point of ridiculousness. I can no longer go into court with a straight face. So your own attorneys are now bailing on you. So your co-counsel has bailed on you, the court has bailed on you, and your own attorneys have bailed on you. This might be a clue that maybe you have the wrong position. 2 months passed before a new attorney sought to appear only as local counsel because I don't want to really appear in this case, but I'll help only for the purposes of local counsel, sure. And Needle moved to leave to appear pro hoc vice on behalf of the company. So the company itself is the one that's being sued. So we have Needle the person and Needle the company, right? So you need to be an attorney to represent the company, even if you are the attorney, right? So Needle wants to represent Needle the company, but it doesn't have license in this jurisdiction. So we need an attorney to represent the company. So he says, well, I'll do it. I'm already an attorney. Can you give me pro hoc vice status? Which is basically for this occasion. I'm already an attorney. Can you say, well, this business needs an attorney, but I'm an attorney, but not in this court. So can you just let me have it so I can do it? Okay. The district court attempted to address the pro hoc vici application and the issues that went along with it at a status conference. It did not go well, you don't say. The court permitted Needle to appear telephonically at Needle's request, so he did not have to travel from Philadelphia to Chicago. Reasonable enough, it's just a pro hoc motion. So, telephone would probably be fine, so sure. But Needle failed to call the court at the scheduled time. When Needle's local counsel then called him from the courtroom, Needle blamed the court staff for giving him the wrong number. Who believes that? The bigger problem, however, was that Needle took the call on his cell phone in a public forum from a courthouse in Philadelphia. Needle could not participate effectively because of the ambient noise on his end. Wow. Just wow, right? It's like, okay, we want to have a conversation on an issue. Maybe we need to pick a room that's a little quieter. It's not like courtrooms don't have this, right? Courthouses have rooms for like discussions for all kinds of things. So like you could have borrowed one of those rooms, that would have been fine, to borrow one of the side rooms to have a discussion or find a quiet space. But apparently you decide to have this call like in the middle of the lobby or something, and no one can hear you. And you failed to call at the wrong time. What is your problem? That's what I want to know. Hello, Railway Hacker. The court was understandably frustrated, you don't say. It accommodated Needle by allowing him to participate telephonically, and Needle abused the privilege by, having a conversation in the middle of a bus station or something. The court continued the hearing to another date. So continued is just hold it over. So they continued it. So they said, well, we're going to try this another time. And ordered Needle to pay the cost of counsel's in-person attendance at the hearing, which is fair enough. That counsel has to charge their clients, and they were there, and you screwed this up, so you should pay their costs, which is a perfectly reasonable sanction in this situation. So the court seems to be kind of nice at this point. At the rescheduled hearing, so at try 2, Needle asserted only the lawyer witness objection to his pro hoc objection was premature. I don't even know. But the legal issues at hand would inevitably require Needle's testimony. Yeah, lawyer as witness, right? So the issue is, if the lawyer is going to be a witness, then you can't also be a lawyer as a general rule. So a lawyer can also be a witness. So he said that the lawyer witness objection was premature. Okay. And it would seem to me, on blush, that the lawyer witness rule would apply in this circumstance. Because, although the corporation is legally distinct, it is in fact like the same person, right? Needle is Needle. It appears to be a very small firm. And he's certainly a witness because it was his agreements, his thing. So yeah, he is a direct witness to this. So like the lawyer witness rule would seem to apply in this situation. So one would presume, all else being equal, he can't be a lawyer because he also has to be a witness, and you can't be both at the same time. So it would seem to me that would be the rule. He's arguing it's premature. Maybe it is, maybe it isn't premature, but I would imagine at some point it's going to pop up, sure. But those legal issues would inevitably require testimony, because of course it is. Because we have to determine what the lawyer did and didn't, and so we'd have to have your testimony. And thus, it was ripe for ruling. I don't quite agree with that conclusion. Yes, it does require his witness. It will require him to be a witness. But in this frame, it's a limited purpose witness. So I think we can get by with it. We have to have the determination if the lawyer is a witness, and to do that, we have to call the lawyer to figure out whether or not he's a witness to exclude. So, like, it is a little inception-y, right? So I think, therefore, I have to look at the case law and stuff like that, but at least for me, I don't think it quite follows. I think we can allow the risk that you're potentially both at the same time for this very limited purpose, because otherwise, like, we're just chasing our tail. So I don't know that quite follows, but that's what the court said. Fine. The court denied Needle's motion to appear pro hoc vice, presumably based on this, and directed local counsel to discuss the scope of representation. 3 days later, local counsel withdrew. So we have another attorney bailing on you. This attorney was there only to be local counsel because the rules require a local counsel, right? I don't think they really should, but they do. As a matter of policy, I don't think that should. I don't think you should need a local counsel. I think it's a little bit weird. What's the purpose of it? I'm not quite sure. But the rules require it. And so this guy said, I'm there only to be local counsel. This is your case. I'm here only as a figurehead. I'm here only as the figurehead, to provide you the ability to do this. And the court said, well, no, I'm not going to allow this. So I want you to try the case. And 3 days later, he said, nope, I'm out. Nope, I'm out. I wasn't here to do any of this thing. I don't want a piece of this. We're off. It's just going great. Don't put this part of the discussion in the edited version. But Theodadius asked, didn't Needle already need pro hoc vice status for the RICO? We have moved back in time, right? We're discussing like how we came here. We're discussing the procedural history. So we haven't gotten that far yet at this point in history. Like ultimately, like, yeah, you would need the pro hoc vici status for the RICO or whatever, but we haven't gotten that far yet. And also like the pro hoc vici status for the RICO and the pro hoc vici status for this are two separate cases. They're two separate cases, so they have to be considered separately. So did he get pro hoc vici for the RICO? Yeah, but now it's a different case, so he needs pro hoc vici status again. And so again, it has to be considered again. So it doesn't flow. So we've moved differently in time, and it's a different case. So exclude that discussion because I don't think it's going to flow well with the overall discussion. Needle then went 6 additional months without a lawyer, and the litigation stalled. Needle himself decided to ignore litigation, which is always great, by not being on the telephone, not talking to anybody. In an effort to get the case back on track, the court reluctantly permitted him to appear pro hoc vice. So the court is like, okay, fine. In an effort to try this, we'll give you pro hoc vice status. Fine. Further, the court permitted Needle to refile a second amended counterclaims that they previously attempted to file without leave, which you can't do. You have to ask for permission. In doing so, however, the court gave Needle a strict order. File it, but don't make any substantive changes. Okay, you can file it. Okay, you can file it. Just don't change it. Needle obviously understood. How could he not? Responding, I'm not going to do anything other than what I just said about correcting two typographical errors. So the court said, don't change it. And he said, I'm not. I'm just going to correct a couple typos. Is that what happened? Mere days after the hearing, Needle indicated his intent to ignore the order and his own promise to the court by telling opposing counsel he is working on revised versions of the amended proceeding, which would add details. What did we just say? The judge held another hearing for the sole purpose of making an already plain court order even more plain. Did you not understand the first time? You can't do this. Nonetheless, later that day, Needle filed a motion for leave to file under seal, attaching the proposed filings that contained numerous changes. What did we just say? The district court was not amused. No joke. The judge nevertheless gave Needle yet another chance to file the complaint. We're going to give us another try. Please just file it without any changes. Did that work? The third time was not the charm. Needle still did not obey the order. Jesus Christ. Because of Needle's stubborn refusal to comply, to refile, the judge rejected the proposed amended pleadings. No joke. This guy is special. What is your problem? At this point, a year and a half after the proceedings and over 300 docket entries, why is this not ended? The case had still not progressed past the pleading stages. Wow. A year and a half later, after 300 docket agencies, we haven't made it past the pleadings. Lord have mercy. I don't know that I've ever heard of such a thing. This is outrageous. If you're in the double digits and you haven't gotten past the pleading stages, you may have a problem. Lord. In addition to the amended pleading debacle and the willful violation of the order, over the course of the next several months, Needle repeatedly and continuously failed to adhere to scheduling deadlines and requested extensions at the last minutes, sometimes on the actual due date of submission, which in turn would upset preset hearings. Man. To make matters worse, how can they get any worse? When he requested extra time to comply, Needle took the time to file several lengthy submissions related to ancillary and unrelated issues. So you're basically abusing all the other latitude of the court. You're abusing all the latitude. Man, what is your issue? Because of the inappropriateness of the conduct during the limited period since they were granted pro hoc vitae status, the status was again revoked. No joke. 2 years into the litigation, the company still did not have an operative pleading. Wow. 2 years into the lawsuit, we still don't have an operative pleading. We don't have something that's actually binding. Wow. That's just amazing. Jeez. Three months later, Needle had still not retained counsel nearly 15 months after the local counsel withdrew. Due to failure to comply with the court's repeated order to obtain counsel, coupled with the litigation tactics and the false statements previously revealed, the judge revoked the pro hoc statute status once again. Royce then moved for an order of default. It's about time, Lord, because Needle had failed to defend the action by not obtaining counsel. The judge was set to retire soon, so the fee action was randomly reassigned to another judge. When the case came to him in 2017, he was 2.5 years old and largely been consumed by needless disputes. Following determination regarding the retainer fee, the Royce Needle fee dispute, which required that direct participation was sole remaining issue. I don't know why we hadn't had a motion to dismiss. This is insane. The agreement, the actual substantive issue, which we're now going to discuss, finally, Lord. The co-counsel's agreement, which Needle drafted, provided attorney's fees as following. That will be divided as follows. Half of any such fee will be divided equally, regardless of time of effort, 25% each. And the second half of any such fee will be divided in proportion you and I have spent, regardless of an hourly rate. So we're just looking straight at time. Fine. Thus, we come to the end of the dispute, thank God. The district court entered final judgment. The district court precisely distributed the actions to $4.2 million, now $4.0 million, because some of it had been consumed by all this mess. Just great. Among the attorneys, after the final judgment was entered, Needle moved for a new trial or to alter judgment. This is amazing. What is this guy's problem, man? What is this guy's problem? Massive failures to obey the court. Massive abuse of what latitude the court was giving you. And like after all this, you want to move for a new trial and all this stuff? What is your problem? The fee action was finally disposed of 3.5 years of litigation. It should have not taken anything like this long. It shouldn't have taken anything even remotely close to this long. We should have been able to do it like in 6 months tops. This is amazing. You can only say this guy is really, really greedy. He really wants every last dollar. Man. We review a district court's dismissal for failure to state a claim without deference. We take all pleaded facts as true and draw reasonable inferences in the non-moving party's favor. The attorney's fee section that says, the attorney's fee section says, they'll be entitled to any contingent fee equal to greater of any fee paid to us pursuant to judgment and award of fees under RICO or other fee-shifting statutes, or pursuant to any settlement, or 1/3 of any recovery actually received, with recovery computed by damages and blah, blah, blah. Okay, fine. Needle claims that subparagraph A of the fee controls the attorney's fees as opposed to B. Okay. This is because, according to Needle, a $2.5 million attorney's fee was separately negotiated during the discussion that led to the settlement, which was allegedly included under the lump sum. Under this reading of the provision, then, the sub-paragraph applies because the attorney's fees is paid to us pursuant to a settlement agreement. Otherwise, the 1/3 floor prohibited would net him far less. This agreement turns upon the contract, so we looked at Illinois state law. It seems like a reasonably easy contract issue, right? It just seems like a very easy contract issue. Like, can't we just get to the actual issue? Apparently, no, we can't do that for some reason. It is uncontested the settlement agreement itself does not provide for the attorney's fees. The settlement agrees that we're just going to pay you $4.2 million and sets forth the payment schedule. There's no term, reference, or hint to the attorney's fees, not even an implication. We could stop here. Yeah. It defies common sense to argue an attorney's fee is pursuant to a settlement agreement that says absolutely nothing of the sort. Nevertheless, Needle insists pursuant to carries a broad meaning that does not demand the settlement agreement state the attorney's fees. Of course, pursuant to can have multiple meanings. Indeed, pursuant to can mean in compliance with, in accordance with, or under, as authorized, or in carrying out. If an alleged attorney's fee is authorized by the settlement agreement, or the attorney's fee is to be paid out in compliance with, or part of carrying out the settlement agreement, the attorney's fees must find its root in the settlement agreement. There must be something, but there's nothing. There's no plausible construction pursuant to that would mean allegedly separately negotiated, non-contractual, and non-identified fee is paid pursuant to the agreement. Yeah, it's not pursuant to the agreement because the agreement says absolutely nothing about it whatsoever. So it can't be pursuant to the agreement because there's nothing in the agreement. It seems pretty clear to me, yeah. Needle's argument also suffers from a factual flaw. Just one. Over the course of litigation, Needle has relentlessly avowed the $2.5 million was separately negotiated, yet he's never identified a separate piece of evidence that supports the claim. Like, whatever. The plain language of the contingent fee agreement dictates the attorney's fee is determined under the section or 1/3 less any retainer. And Railway Hacker, no, I have not covered Prenda law. I've not covered any of that stuff. With all that finally being out of the way, the court must turn to the issue of whether or not sanctions are due. The district court sanctioned the company for filing counterclaims seeking declaratory judgment. The attorney fee is governed by a section of the contingency fee agreement the court has deemed frivolous. They sound frivolous to me. We may have to adopt a new rule on the channel that forbids the mention of other law channels or something. I don't know. But no, we haven't discussed it. Needle was not sanctioned because of its position turned out to be wrong, because it was frivolous, disregarding what anyone had taken in a first-year contracts class, and utterly devoid of merit. There was no attempt to construe the contingency fee according to generally acceptable principles of contract interpretation. Sounds that way to me. I don't know what the problem is. Man, we are really, really greedy for this money is all I can say. Finally, the conclusion. This relatively straightforward attorney's fee dispute was made exceedingly difficult by one attorney who took a frivolous legal position and turned it into a multi-year litigation conduct. The district court did not err in its ruling or abuse of discretion imposing sanctions, and it is affirmed. So that is the end of our discussion of the case of Merrill Royce versus Michael Needle Company. In this case, we learned that Michael Needle really, really wanted some money for RICO. And, there was no agreement that said, and then they went for 3 years despite fighting multiple orders and all the rest of it. Now, personally, if I were the district court, given all that behavior from this guy, I probably would have said you don't get anything at all. I probably would have said no money for you at all and see whether or not that's an abuse of discretion. The district court actually said that you can get some money, which is amazing, but they did give Rule 11 sanctions on top of it. So personally, if I were the district court at this point, I would have said, yeah, you don't get any money, screw you. But they didn't go that way. So Michael Needle was not happy with his limited award and fought, even though he was disobeying orders and abusing discretion, all kinds of stuff. And so the court said, no, you're just being a jerk. And that is the end of this case. All right. I'm going to very quickly make myself a yogurt because I'm a little hungry. So, talks amongst yourselves. Talks amongst yourselves. I will talk to you through the very echoey room as I make my yogurt. Yogurt is good for you. Yogurt is tasty and nutritious. Yogurt is tasty and nutritious. I wish I had blueberries, but I rarely have. Very sad. If there's anyone out there who's saying that this isn't very professional of me, well, it's my stream and I want yogurt. So that's what we're doing now. One of the benefits from filming from my home, I suppose. All right. Yogurt is ready. Yogurt has been prepared. I'm coming back. Good stuff. Good yogurt. All right. I want some more yogurt. Can the court do that? Say no, you get nada. I would imagine, as part of it, as part of the abuse of discretion analysis, I would imagine the court can do that as a sanction. I mean, one hell of a Rule 11 sanction. Why not? Yeah, I assume so. And given all this, it doesn't seem like abuse of discretion to me. All right. Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case of Doi Mai versus the ATF, Bureau of Alcohol, Tobacco, and Firearms. In this case, Mr. Mai was adjudicated as mentally defective. He was put in a mental hospital, but this occurred quite some number of years ago. So he would like to purchase a firearm, and under the relevant law, you can't do that if you've been adjudicated mentally defective. But he says it's happened so long ago that as to him, it should no longer apply. So the court is going to get into the issue as to whether or not this infringes on his Second Amendment rights by giving him a lifetime ban from the ownership of firearms, even though his condition has arguably subsided. So let's read this. Brian, we discussed what kind of cases this stream. We discussed at the beginning of the stream. Doi Mai recently sought to buy a firearm, but federal law bars him from doing so. A number of years ago, a plaintiff was committed involuntarily for more than 9 months to a mental institute after Washington State found him to be both mentally ill and dangerous. 18 U.S.C. 922 prohibits the possession of firearms by those who, like plaintiff, who a court has committed involuntarily to a mental institution. So under the federal law, you can be disqualified from owning a firearm for various reasons. Some of these are temporary and some of them are not. Some of these reasons include if you've ever given up your U.S. citizenship, if you've been convicted of a felony, if you were dishonorably discharged from the military, if you currently have a domestic violence order, and I think some convictions for domestic violence, including even misdemeanor convictions, I think can be a thing, and as is applicable here, mental health. So according to the law, if you've ever been adjudicated mentally defective, then you're disqualified for life from owning a firearm, and that is the situation here. In October of 1999, a Washington State court committed plaintiff involuntarily to mental health treatment after he threatened himself and others. The district court determined that he was both dangerous mentally ill and dangerous. Plaintiff's commitment lasted 9 months, ending in August of 2000. Plaintiff was 17 years old at the time, and his commitment spanned into his 18th birthday. So this was 20 years ago, and at the time he was 17, and so he has aged and matured, and the condition seems to have potentially become alleviated since then. Since his release from commitment in 2000, plaintiff has earned a GED, a bachelor's degree, and a master's degree. He's gainfully employed and a father of 2. According to the complaint, he no longer suffers from mental illness and lives a socially responsible, well-balanced, and accomplished life. So whatever problem he had when he's 17 seems to have become mooted. As a result of plaintiff's involuntary commitment, Washington law prohibited him from possessing a firearm. Washington law, though, allows a person to petition for relief from that prohibition if they meet certain conditions. So there's a way to get status if you are denied status. In 2014, plaintiffs successfully petitioned Washington State Court for relief. The court found that pursuant to the requirements, that plaintiff is no longer required to participate in a court-ordered inpatient or outpatient treatment. Plaintiff has successfully managed the condition related to commitment, and he no longer poses a substantial danger to himself or the public, and the symptoms are not likely to reoccur. Okay. Accordingly, the relevant state law no longer prohibits plaintiff from possessing the firearm. But, as a result of the involuntary commitment, federal law prohibits plaintiff from possessing the firearm. Title 18, 922 bars individuals who have been committed to a mental institution from possessing firearms. Federal regulations make clear that prohibition does not apply to a person in a mental institution for whom observation or voluntarily admitted to a mental institution. So if you're just there for observation or if you're there voluntarily, it does not apply to you. Involuntary commitments, on the other hand, comport with due process only when the individual is found to be both mentally ill and dangerous. So it has to be adjudicated mental illness after due process. We agree with the parties that plaintiff's involuntary commitment by the Washington State Court, which found plaintiff to be both mentally ill and dangerous, qualifies as commitment under the relevant law, and therefore he's barred from possessing a firearm. Federal law provides two potential avenues to relief from the law, but as explained below, neither avenue is currently available. First, under 18 U.S.C. 925, the plaintiff may apply to the Attorney General for relief from disability imposed by the federal law with respect to possession of firearms. Beginning in 1986, however, that provision was extended to persons who had been involuntarily committed, so you can ask for relief. The Attorney General may, but is not required to grant relief if it's established to his satisfaction that circumstances regarding the disability and the record and reputation are such that the applicant will not be likely to act in a manner dangerous to the safety, and granting of relief would not be contrary to public interest. That statutory option, however, is currently foreclosed to plaintiff and others. Since 1992, Congress has prohibited the use of funds to investigate or act upon applications for relief for federal firearms disabilities under the law. So even though the law allows for it, Congress has not given any money. If you can't spend money, then you can't do a thing, right? We were discussing this a little bit when it came to freedom of speech. If you want to restrict freedom of speech, there's two ways to do it. Restrict freedom of speech or restrict money. Here, it's like if you want to prevent people from getting their firearms rights back, there's two ways to do it. Restrict them from getting their firearms rights back or just deny the money to do it. Either way is equally good, and that's what Congress did. Congress defunded the program because, among other reasons, determining eligibility had proved to be very difficult and subjective, which could be a devastating consequence if the wrong decision is made. Accordingly, unless Congress chooses in the future to fund a federal program, any application by plaintiff for relief pursuant to law would be futile. Plaintiff's second potential avenue for relief is through a state program that qualifies under law. To qualify, the state program must permit a person who, pursuant to law, has been committed to a mental institution to apply to the state for relief from disabilities imposed by law. So they allow for estate relief. According to the government, approximately 30 states have created qualifying programs. As noted above, Washington law provides a mechanism for persons to petition for relief from state law prohibition, but that mechanism does not qualify under the federal statute because, among other reasons, the factual findings required by Washington law differ from those required by the federal law. Washington law requires a finding that the person no longer presents a substantial danger to himself. By contrast, the federal standard requires a determination that the person will not be likely to act in a manner dangerous to public safety. So it's a different standard. So the Washington relief doesn't qualify because they're reaching a different question. With that out of the way, we have to discuss the Second Amendment and how it might apply to this situation. The Second Amendment protects the right to keep and bear arms for the purposes of self-defense. But the right is not unlimited. The Supreme Court clarified its recognition that the Second Amendment right does not cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding carrying of firearms into sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on commercial sale of arms. Whether the prohibition on possession of firearms by a person who have been committed to a mental institution comports with the Second Amendment is an issue of first impression in this particular circuit. Decisions by the Third and Sixth Circuits addressing the law also inform our analysis. Those courts have addressed challenges remarkably similar to plaintiff's challenge and have reached opposing conclusions. The Third Circuit rejected the claim, concluding that the law did not burden conduct protected by the Second Amendment. Accordingly, the plaintiff allegedly returned to mental health was irrelevant to that constitutional analysis in that circuit. By contrast, the Sixth Circuit reversed the district court's dismissal and remanded for further proceedings. That court then held the statute did not survive intermediate scrutiny as applies to the plaintiff because the government had failed to show that a lifetime prohibition was a reasonable fit to the goals of the statute. So they said it was unconstitutional as applied to them. This circuit thus turns to its own analysis to figure it out. The government has presented a strong argument that both of the inquiries support the conclusion that it does not burden the Second Amendment right. The Supreme Court identified as presumptively lawful a long-standing prohibition on possessions of firearms by felons and the mentally ill. Plaintiff responds by reframing the inquiry. He concedes that her prohibition as to those persons who are presently mentally ill and dangerous does not implicate the Second Amendment. No. I'm not going to allow advertising of other channels on this overtly. So I'm removing the message because I'm not going to allow advertising of other channels overtly. So new rule to the moderators: they can remove anyone who is overtly asking for subscribers or to another channel. So that is a new rule now. Which is also incidentally why I removed the message rather than timing you out, because I hadn't given you notice before. So now I've given you notice. Aren't I nice? We next determine the appropriate level of scrutiny to apply. The precise level of heightened scrutiny depends on how close the law comes to the core of the Second Amendment right and the severity of the law's burden on the right. There has been near unanimity in the post-Heller case law that where considering regulations that fall within the scope of the amendment, intermediate scrutiny is appropriate. That is the general rule, yes. Strict scrutiny applies only to laws that implicate both a core Second Amendment right and place a substantial burden on the right. Yeah, the general consensus from the courts of appeals so far is that intermediate scrutiny is subject to is the right standard for Second Amendment cases. A rule that I have some quibbles with at best, but that is a fair statement of it. That same logic extends here. Regardless of present-day peaceableness, a person who requires formal intervention and involuntary commitment by the state because of the person's dangerousness is not a law-abiding responsible citizen. Not sure I completely agree with that conclusion, but okay. We recognize the burden the statute places on plaintiff is quite substantial. Unless Congress or Washington State Legislature enacts a program relieving him of the law amounts to a total prohibition, in fact, a lifetime ban. But we agree with the Sixth Circuit that, like other provisions of the law, it does not place a burden on the public at large. It burdens only a narrow class of individuals who are not at the core of the Second Amendment and those who are previously involuntarily committed. In sum, although scientific evidence suggests plaintiff's increased risk of self-harm decreases over time, nothing suggests that it ever dissipates entirely, which is a bit unfair because, there are a lot of people for whom it doesn't dissipate entirely, but who haven't been adjudicated. So I don't know that's quite fair, but all right. Scientific evidence thus supports that congressional judgment that those who have been involuntarily committed to a hospital continue to pose an increased risk of violence even many years after their release. Plaintiff asserts that because he was released from commitment many years ago, 20 years ago at this point to be more precise, he no longer suffers from mental illness and has been peaceable in his recent years. The Second Amendment requires that he be allowed to possess the firearms. But we emphasize that we're addressing congressional judgment about a category of persons, not about plaintiff himself, which is slightly odd because we would normally be thinking this as an as-applied challenge, but okay. As described above, scientific evidence reasonably supports the congressional judgment about the category of persons. In sum, we hold that the statute's prohibition to those who have been involuntarily committed to a mental institution is a reasonable fit for the important goal of reducing gun violence. The district court therefore correctly granted the government's motion to dismiss. Because factual allegations in the proposed amended complaint do not affect our analysis, the district court correctly denied, as futile, any leave to amend the complaint. Thus, that is the end of our coverage of the case of Doi Mai versus the ATF. In this case, we learned that Mr. Mai was involuntarily committed to a mental hospital when he was 17 years old and stayed for 9 months. That was 20 years ago, and since then he appears to be in relatively good mental health, obtaining multiple college degrees, having a family, and living a responsible life. He thinks that the statute that prohibits anyone adjudicated from being mentally defective from owning a firearm is not constitutional as to him. And the Ninth Circuit Court of Appeals, perhaps not surprisingly, decides to not look at him in particular, but decides to only look at the category of people. Personally, I think that's a little bit off. When you're looking as an as-applied challenge, you're looking at as applied, as to this person in particular. So to refocus the analysis on the group seems a little off point. But it's the Ninth Circuit. I don't think they're in a particular hurry to give anyone a right to a firearm if they can avoid it. So it makes sense as to their conclusion. I just think it's a little legally dubious. So unfortunately, he does not get his firearm, and he is disqualified for life, and that is the end of the coverage of this case. Yeah. I'm not really sure I agree with the court either. I'm not really sure I agree with the court either. When you're doing an as applied challenge, you should look to the person as applied. And so for them to make it collective doesn't seem in keeping with an as applied challenge to my mind. Sure, it can go to the Supreme Court. It won't, but it could. The reason I say I won't is because there's not enough foundational case law. Let me put it this way. If you're interested in gun rights, you don't want this case to go to the U.S. Supreme Court. There's not enough foundational case law at this time to justify any sort of reasonable probability that this would go the other way. It's much more likely that it would be bad precedent than good precedent. You have to do this in stages. So you have a couple good right to keep cases. What you really need is a good right to bear case. That would be the next case you want to go to the Supreme Court, is a good right to bear case. So you'd want some case dealing with concealed carry permits, presumably. So you got a couple candidates, particularly in the Ninth Circuit, that are percolating around. What's the guy's name? Perito or something like that? That's still percolating around. So there's a couple cases. So what you really want to go to the U.S. Supreme Court next is a good right to bear case, to establish there's some foundational right to a right to bear. And then we can talk about the next case after that. But you don't want this case to go. There's not enough foundational case law at the U.S. Supreme Court level. And it's skipping too many steps. It would be a very bad idea to take this to the U.S. Supreme Court. Bad idea. It reminds when I say stuff like that, it reminds me a little bit of Alan Gura when he was bringing Heller, and a lot of gun rights people gave him crap for his oral argument because in his oral argument he was pretty like they asked about what about machine guns, and he's like machine guns aren't included, and everyone's like you idiot, of course they're included. But what Gura realized, and I know he realized this because he talked about it later, what he realized is I can't make that argument. If I start talking about machine guns, you know, it's too much. It's too much. I'm going to lose the handgun argument if I start talking about machine guns. So he very wisely didn't bring that up. We're trying to lay very small bricks to lead to something. So if you want a machine gun case, Heller is not the case to do that in. So, Alan Gura was 100% strategically right. 100% strategically right. And so, you don't want to bring this case to the U.S. Supreme Court. You're going to go down in flames. You'll go down in flames hard. It's a bad case. Bring a really good right to bear case. That's the case you want to be brought. It's also incidentally I've said this before. I said this about NYS RPY, right? RPA. We said this about NYS RPA. Right? The case we didn't cover because it turned out to be a nothing burger. But NYS RPA was arguably a good right to bear case, which is why New York freaked the hell out when the Supreme Court took cert and tried to make it not a good right to bear case, specifically because of this. NYS RPA was taken as a right to bear case, and New York State freaked out and made it not a good right to bear case, to avoid this issue. So, Supreme Court tried, but this Peruta case out of California is probably the next best case. So, it'll eventually pop up one day. Hello, everyone, and welcome to One Civil Law. For today's case, we have the decision of Megan McGuire versus Corey Cooper. In this case, there was a sheriff who was investigating a traffic stop, and they found some marijuana. And they also found that this person who had marijuana had a girlfriend also in the car. And so they basically solicited this girlfriend to do things to them in order to drop charges against the boyfriend. The girlfriend is not happy about this situation and is bringing a complaint. So we're going to find out whether or not the police can hold threat of arrest over your head, either of that you personally or of a significant other, in order to get you to perform certain acts on them. And assuming that they do that, whether or not they're immune from liability under qualified immunity. So let's get started with this. At around 8 p.m. on February the 10th, 2013, Cooper, an off-duty deputy officer employed by the Douglas County Sheriff Officer, approached Kyle Worland's truck, parked at Zorsky Lake Park in Omaha, Nebraska. Worland, McGuire's boyfriend, was seated in the driver's seat, and McGuire was seated in the passenger seat. When Cooper approached the passenger seat of the truck, he smelled marijuana. While shining his flashlight into the interior of the truck, he observed a mason jar containing marijuana located on the center console. Cooper took possession of the jar and told McGuire to step out of the truck. Cooper walked McGuire to his patrol car and directed her to sit in the back seat. He put the marijuana on the roof of his car. After ascertaining information about McGuire and Worland, Cooper retrieved Worland from the front seat of the truck and placed him next to McGuire in the back of the patrol car. Cooper proceeded to search Worland's truck and found drug paraphernalia. After the search, Cooper walked Worland back to his truck and spoke to Worland out of McGuire's earshot. Cooper then returned to his car and informed McGuire that he had found stuff, and Worland could go to jail if he reported the incident. Instead of reporting the incident, Cooper began asking McGuire questions about what she would do to keep her boyfriend out of jail. As Cooper was talking to McGuire in the patrol car, Worland walked towards the lake and discarded the drug paraphernalia. So this is going really, really good, right? It's like, what would you be willing to do to keep him out of jail? Well, it's like, okay, this is promising, great. Cooper pressed McGuire. Cooper pressed McGuire for nearly an hour about what she was willing to do to keep the boyfriend out of jail. Confused and scared, McGuire eventually asked Cooper if he wanted her to undress. Cooper purportedly replied, "I am not going to say no," or words to that effect. Cooper then stared at McGuire through his rearview mirror while McGuire removed the shirt and bra. Cooper then got out of the front seat, opened the passenger door, unzipped his pants, and asked McGuire what else she would do. Okay. McGuire performed acts on Cooper for about 5 seconds. Yeah. At which point, Cooper released McGuire and she ran to Worland's truck and they drove away. One can only begin to speculate as to the very short time interval if he was finished within 5 seconds, but okay, that's what happened. McGuire reported the incident to the Oklahoma Police Department in February of the 14th, 2013, Valentine's Day. What a Valentine's Day gift. The Oklahoma Police Department contacted Douglas County Sheriff's Office about a week later to inform the sheriff it was investigating the assault by a law enforcement officer. The sheriff's office did not commence its own investigation. Great. On April the 1st, April Fool's Day, we just love the timing of these things. On April the 1st, a sheriff's deputy reported to Cooper that he had suspicious interaction with a woman with an arrest warrant to whom Cooper had asked to meet in a secluded park at 9 o'clock. Cooper was placed on limited duty status on April the 4th. Only after this report of suspicious behavior did the sheriff's office commence its own investigation. The sheriff's office discovered Cooper had run a record check on Worland and McGuire, and that the GPS in Cooper's car placed Cooper at the park at the time of the assault. Cooper was terminated by the sheriff. In June of 2013, Cooper was charged with first-degree sexual assault, criminal charges. Cooper pled no contest and was found guilty to third-degree assault and attempted tampering with evidence, presumably by disposing of the contraband in the lake, which were Class 1 misdemeanors. On June the 10th, 2015, a state district judge in Douglas County sentenced Cooper to consecutive terms of 6 months on each count. Wow, that's a fair amount of time, guys. Because you're talking about guilty of third-degree assault and tampering with evidence. So that's a year, right? Because that's two 6-month terms consecutive. So, it's not nothing, man. Whether or not they deserve more, it's, third-degree assault sounds plausible. Attempted tampering with evidence sounds plausible. And so we're giving this guy a year. That's not bad. It's not necessarily great, but it's not bad. Given what the police normally get, I think we can all take some comfort that they got something, is basically what I'm trying to say. At the time of the incident with McGuire, the Douglas County Sheriff's Office did not have a policy of reviewing behavior to determine those at risk for misconduct. It did not have a comprehensive policy addressing misconduct. They had no policy on it, presumably because they didn't think it needed to be said. So, okay. The Sheriff's Office had implemented, however, a citizens complaint process whereby citizens could submit complaints for review. Since the office's appointment in 1995, there have been at least 15 complaints of misconduct employed by the Sheriff's Office. Great. As to the claims against Sheriff Dunning and potential liability, the district court found that because Sheriff Dunning was notified of every citizen's complaint regarding deputies under his supervision and had actual notice of at least 11 of them, a jury could find there was a pattern and practice that involved inappropriate misconduct. The lack of policies and training on misconduct, the lack of investigation into allegations, and the alleged cavalier attitude by the sheriff were sufficient evidence to give rise to a jury question regarding a deliberate indifference. And there was sufficient evidence of a causal link between the failure to train or supervise the employees and the assaultive behavior such that they're not immune from due process, equal protection, and Fourth Amendment claims. So basically what we're trying to say here is that, normally we don't have like a respondeat superior liability when it comes to the government. But, if you have sufficient knowledge, sufficient involvement, sufficient whatever, you can be held responsible. And basically saying you knew for so long about all these issues and you didn't do anything about it, we're coming after you too. So that, we're holding everyone accountable to some degree. That's nice. Qualified immunity is a doctrine that shields a government official from liability unless the conduct violates clearly established statutory or constitutional rights of which a reasonable person would know. Even in the absence of an allegation of direct participation in constitutional violation, a supervising officer may still face liability for alleged failure to train and supervise subordinates. In order to establish a claim for failing to supervise, McGuire must show that Sheriff Dunning received notice of a pattern on unconstitutional acts committed by subordinates, demonstrated deliberate indifference to or tacit authorization of the offensive acts, failed to take sufficient remedial action, and that such failure proximately caused the injury in question. The sheriff contends that even taken in the light most favorable to McGuire, all the reported incidents of prior misconduct by deputies employed, they are entitled to qualified immunity because these incidents are insufficient to provide notice to an on-duty deputy that might assault a member of the Congress, a member of the public like Cooper did. Okay. Constraining ourselves to a version of the facts in the record the district court assumed or likely assumed in favor of McGuire, we conclude that the prior instances of misconduct are not of similar kind or sufficiently egregious in nature to demonstrate a pattern of sexual assault. In order to establish a pattern, our case law requires a showing of more than general allegations of widespread misconduct. It requires the other misconduct to be very similar to the conduct giving way to liability. So we've seen this before in qualified immunity analysis, right? We've seen this before where the court says, you can't look at these things at too high a level of generality. So here, just because in general you were aware that your deputies were doing many, many misconducts, you weren't aware of this specific kind of misconduct. So, it's okay under qualified immunity. All right then, I suppose. Damn, my nose is itchy. I think it's itchy in part because of the bulb. It's itchy in part because of the light. But the light makes me look good. In this case, the other misconduct that was alleged includes trading cigarettes for, flashing, licking a minor stepdaughter's nipples during horseplay. Wow. Okay. All right. Wow. Okay. That's your own stepdaughter. That's what that means, right? Licking a minor's stepdaughter. So, all that, adult entertainment out there that is along stepbrother, stepsister, stepchild themes. Apparently it's based off some kind of reality because one of the other allegations was that these sheriff's deputies were licking a minor stepdaughters. That would be their own stepdaughter, right? A minor stepdaughter's stuff during foreplay. Okay. Asking deeply personal and inappropriate questions to members of the public. Engaging in verbal sexual harassment. Having consensual sexual contact at the office. Well, that's a little less disturbing, but. And abusing work hours to conduct personal business or ask women out on a date. Not so great. While this behavior is troubling, that's one way to put it, troubling, it's not enough to put a supervising official on notice that a deputy might use their position and authority to separate a woman from her boyfriend at the park and coerce her into contact with him. Okay, it is not similar enough to give a reasonable supervisor notice that a deputy might try to do this. Okay, if you say so. The summary judgment record, even when viewed in the light most favorable to McGuire, fails to establish the sheriff received a notice of a pattern of similar unconstitutional acts being committed. Okay. A reasonable officer in this position would not have known they needed to more closely supervise the deputies, including Cooper, or that they might sexually assault a member of the public. A supervisor's failure to train an inferior officer may give rise to individual liability if the failure to train amounts to deliberate indifference to the rights of the person. You know, I'm just a simple country lawyer, but it seems like there might be a little bit of deliberate indifference when it comes to sexual harassment by deputies, given the record that's established. But the court appears to disagree with me. Apparently, you know, this is not sufficiently clear. All right. And if the alleged failure to train actually caused the violation, which, you know, seems to be at least in part. We have previously explained there's no patently obvious need to train officers not to sexually harass assault women. Well, apparently there is, nor is there apparently obvious need to train officers that if they assault women, they may be charged with a felony. Okay. 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 You know, I was under the distinct impression all this time. I was under the distinct impression all this time that excuse and ignorance of the law is not generally excuse. So, you know, I was unaware that you had to train anyone that sexually assaulting someone could be a felony because that would be an ignorance of the law analysis. I didn't know this was against the law. First of all, yes, you did, because it's malum in se. It is inherently bad. You don't need to be trained. You don't need to be told because it is bad in and of itself. You know, we don't need rationales or explanations about why it's bad. You know, everyone knows this is bad. It is bad to sexually assault people. So first, we shouldn't have to train you in any event. Second of all, you can't claim ignorance because of training. But apparently this rule doesn't apply to the police. Apparently, we would need to establish that you need to train someone not to sexually assault people. So like all those people, you know, I don't even begin to understand this. This is wow. A reasonable supervisor in the sheriff's position would not know failure to specifically train not to assault women would cause Cooper to engage in the behavior. Again, given the pattern of conduct, I'm not quite so sure. And again, I'm not sure that you have to train them because, again, should you really have to train someone that sexually assaulting people is bad? Isn't it something that's clearly established? Do we really need to train someone about this? Apparently, though, they are entitled to qualified immunity because we didn't know better or something. Wow, okay, so that's the thing that happened in the case of Megan McGuire versus Corey Cooper. In this case, Miss McGuire was enticed, coerced, extorted into performing certain acts of a nature. And the sheriff in question had received many, many reports that his deputies had done things like this in the past. But we can't sue the sheriff's office because they needed to know that they needed to train people despite a record of ongoing behavior, and they had no way of knowing that failure to train people would lead to this or something. Don't ask me to justify it, and don't shoot the messenger. I'm just telling you what is, right? Not what should be. And this is what is, for better or worse. Personally, I think worse, but that's the end of the discussion of this case. I guess become a police officer is the only reasonable conclusion from this. That's the Court of Appeals for the Eighth Circuit too. Was there even a dissent in this? There wasn't, was there? No, it was unanimous. Okay. The Court of Appeals saw no problem with this. Become a sheriff in Omaha, Nebraska, I guess. Okay. You know, I've expressed more than a few occasions my doubts over qualified immunity. So, yeah. Okay, Eighth Circuit, you do you, I guess. Yeah, you know, I've said before that I don't know if we should nuke qualified immunity because I do think there probably are cases, but it needs another look over. You know, it needs to be put back into a box. This is ridiculous. You know, if you're upset about this qualified immunity case, you know, you might want to brace yourselves because we got stuff coming up later. We're not going to do it now, so you have time to get mad about something else. I just want to let you know. You know, yeah. Hello, everyone, and welcome to Uncivil Law. For today's case, we have an asset forfeiture case. This is United States of America versus $39,000 in currency. In this case, the TSA discovered someone in their luggage with $39,000 in currency. They seized the money. The question at issue is, does the government get to keep this money? So let's get started with this discussion. In 2018, a routine TSA administration screening indicated the presence of an organic bulk mass in the carry-on luggage. Upon examination of the luggage, TSA observed several rubber-banded bundles of mixed denomination currency totaling $39,000. In 2018, the government filed this forfeiture action. Wells filed a verified claim, which just means it was under oath. That's what it means by verified, asserting that he's the sole and absolute owner of the money, that he was in sole and exclusive possession of the money when it was unlawfully removed from his exclusive possession and control, and that he was being victimized by illegal retention of the funds. Subsequently, Wells filed an answer to the government forfeiture complaint, denying the government's allegations on the grounds that the answer could very well tend to or actually violate his Fifth Amendment rights. So he's filing a lawsuit that says, this is my money, I was under control of the money, and the government is responding with, like, what is the money and what's it for? And he wants to invoke the Fifth Amendment right. Now, that will help him in the criminal case, but not in a civil case, because presumptions can be taken against you when you refuse to answer questions under the Fifth Amendment for civil purposes. Pursuant to the rule of Federal Civil Procedure, supplemental rules for admiralty or maritime claims and civil forfeiture actions, the government serves special interrogatories. An interrogatory is just a fancy question for, please answer this question. To Wells seeking information testing his assertion of ownership. In response to each interrogatory, Wells stated claimant refused to answer this interrogatory as asserting his right against self-incrimination. So the government wants to know, like, here are some questions we want to know about, like, what is the source of this money? And he says, I won't answer. Okay. The government moved for summary judgment on the issue of standing, asking the district court to strike Wells' verified claim and answer, along with Wells' naked assertions of ownership, due to failure to respond to discovery requests aimed at determining the legitimacy of it. The district court granted the motion for summary judgment, finding it failed to establish standing. All right. So this makes sense in terms of procedural process, right? So what we have is a motion to dismiss contrasted with a motion for summary judgment, right? In a motion to dismiss, we look at the naked pleadings on their own face. On the naked pleadings on their own face, we have a guy who says under oath, this is my money, it's solely my money, and nothing more. Fine. But then we move into discovery. Discovery, of course, can take many different forms. Discovery can be exchange of documents, it can be depositions, or it can be interrogatories like this. So the government can send you a list of questions that have to be answered under oath. They could have asked you in person during a deposition, but they can do it in writing too. And so they want to do it in writing. They want to do it as a series of interrogatories. Okay, fine. This guy comes back and says, well, I'm not going to answer any of your questions under the Fifth Amendment. Okay, but we're in a civil case. So that means that your failure to answer can be held against you in a civil case. It can't be held against you in a criminal case, but this isn't a criminal case, right? So your failure to answer a question cannot be held against you in a criminal case. In a civil case, it can be held against you. So you can get the court to assume the opposite. So the person comes forward and says, well, look, we asked these questions, they refused to answer it. And that means that that everything can be taken in our favor, right? Like the worst possible answer to this question can be taken as the answer, right? Because that's the rule, right? It can be taken against you. So like the worst possible answer can be assumed, right? And now that's part of the evidence. So now we have two pieces of evidence. We have the original naked assertion, this is mine, and then we have a whole bunch of stuff where, like, under oath, like, you refuse to answer any of these questions. And it's like, well, look at this other evidence. And so now we're on a motion for summary judgment, right? So the court is now looking at the balancing of the evidence and seeing, like, is there enough here? And they say, well, there's enough here, so the government wins. So that's basically what happened. This court reviews a district. This court reviews a district court's decision to strike a claim for an in rem forfeiture, which just means against property. That's what in rem is, as opposed to in persona, which would be against the person. So an in rem forfeiture, action for abuse of discretion. So we look for abuse of discretion when you strike it. However, we review de novo the district court's determination of standing to contest action. Okay, so one of the issues here is, does this guy have standing? And in order to have standing, you have to have an injury that's applicable to you. So they're saying there's not even standing. He can't even bring the complaint because, he hasn't proved that he has an interest. Let's read on. On appeal, Wells argues the government must first establish it lawfully seized the defendant's property before they're required to prove more than mere assertion of ownership. Wells is wrong. Before determining whether the government lawfully seized the property, Wells must establish he has standing to challenge the seizure. Wells bears the burden of demonstrating an interest in the currency sufficient to satisfy the court of his standing, and after discovery, mere physical possession does not suffice to show standing. So mere possession alone doesn't show a sufficient interest for you to sue, because just because you possess it doesn't mean you own it, right? And so we're looking to who's actually been injured by this, and you won't tell us. So we can't assume it's you. Instead, we require some explanation or contextual information regarding the claimant's relationship to the property. A universal invocation of the Fifth Amendment during discovery forecloses any way for the claimant to sustain the burden. A blanket assertion of the Fifth Amendment privilege does not excuse a claimant's burden of establishing standing at summary judgment stage, nor can he use the invocation as a sword to make one's assertions impervious to attack. Right? So you've already made statements, right? And one of the things the Fifth Amendment generally does not protect you against, in general, of course, one of the things the Fifth Amendment does not generally protect you against is cross-examination, either in a criminal trial or otherwise. So if you open the door to something by making a statement on the stand, you can't then claim the Fifth Amendment privilege as it relates to a follow-up question as part of cross-examination. You opened the door. You had the right to remain silent. You surely had the right to remain silent. But you opened the door. So now that you've opened the door, the other side is entitled to cross-examine. You can't invoke the Fifth Amendment. And so it's exactly the same logic here. You've put out an assertion, you own it. The government wants to cross-examine. In this case, they want to cross-examine by an interrogatory because we're doing discovery, and you won't answer any of their questions. So, you can't have it both ways. You can't have it both ways. You can't open the door by offering a verified complaint, which is under oath, so you can't have it both ways. You can't swear the money's yours and then also refuse to answer any questions. That's not how any of this works. Otherwise, Wells' claim of privilege could allow him to proceed with what may be false evidence, because we have no way of testing it, no way of cross-examining, while depriving the government of any means to detect the falsity. You have no ability to confront, no ability to contest, no ability to cross-examine, because the guy's going to plead the Fifth. So all we have left is the naked assertion. That's not fair to anybody. Accordingly, we find the district court properly struck the verified claim and answer due to the failure to establish standing. We don't know it's yours because you won't answer our question. Left with nothing more than a record devoid of any claim of ownership to seize currency, the district court properly found the government was entitled to summary judgment due to Wells' lack of standing. And for these reasons, we affirm. So that is the end of our coverage of United States of America versus $39,000 in change. In this case, we learned that a person had $39,000 when they went through TSA. The government found it. They argued under oath it was theirs, but then they refused to engage in any discovery. They refused to engage in cross-examination, in this case in the form of a interrogatory, by asking for the source of the money. And they opened the door, so it can't have both ways. They can't open the door and say, you can't ask me questions. That's not fair. So as a result of all this, the money is getting seized. It does not have to be returned to Wells because he did not engage in the process. And that is the end of our coverage of this case. Hello, everyone, and welcome to I'm not sure that I would say that it's burden of proof issue. It's that, as I was saying before, if you refuse to answer questions in a civil case, that can be taken against you. So, the government has enough evidence to say it's not yours because, you won't say it's yours. I'd just like to state for the record that, plain yogurt with a little bit of honey on it and some pistachio nuts is very tasty. All right. We got 33 people watching this. That's nice. 33 people. 33 people joining this stream. I just had a really bad idea. I saw a video, I think it was from The Quartering, where this like Twitch channel has a animated wafu who does like everything, and like people give the wafu insane amounts of money. I should turn this into a wafu law stream. That would be good. I should turn this into a wafu law stream. I should get myself a really, really sexy wafu animated and make them read law stuff. That'd be. I might do it. I might do it. This uncivil law may become wafu law at some point in the near future. I'm just telling you right now. Hello, everyone, and welcome to One Civil Law. For today's case, we have a decision in the case of Karen McNeil versus Community Probation Services. In this case, we are dealing with an appeal that arises out of a lawsuit dealing with bail and probation, and we're attempting to hold the probation services themselves responsible for their component of it. So we're going to look to the degree to which the probation services can be held accountable for their participation in the bail system. So let's get started with this. This appeal arises out of a lawsuit challenging the way Giles County, Tennessee, determines bail, privatizes probation supervision, and collects fees. Last time we tangled with this litigation, the sheriff and county appealed a preliminary injunction stemming from the bail-focused claims against them. This time, a probation company and one of its employees appear the denial of the motion for summary judgment, raising immunities, we affirm. Giles County contracts with two private probation companies to supervise the probation of people it convicts of misdemeanors. A putative class of misdemeanants sued both companies, some employees of each company, the county, and the county sheriff. They allege the defendants have committed federal constitutional violations, racketeering violations, and state law torts. The plaintiff seeks injunction to stop the company's continued operations and damages for what's already happened. This appeal involves just one company and one employee. Community Probation Services and probation officer Patricia McNair raised qualified immunity and sovereign immunity defenses. We have authority over the appeal because denials of the anti-suit immunities receive immediate appellate review. So one of the first things you immediately note here is that these are private actors, but they are arguing government defenses. They're arguing qualified immunity and sovereign immunity. Those are government arguments. One of the things you would look to determine this is whether or not the private entity is actually a government. And to determine that, you look to, among other things, how they act, their interrelatedship, and the stuff they perform to determine whether or not they're performing government roles. So, you can't get outside of this, outside of government action just by doing it through private entities. So we have to look to see whether or not these are private entities or actually the government. So let's read on. Qualified immunity partially, though not completely, protects government employees from personal liability for actions. In invoking the defense, the company and McNair trip over the reality that they face no damages of prospective damages liability. Start with the company. The complaint does not contain an individual capacity claim against the company, nor does any feature of the course of the proceedings. On top of that, the plaintiff has represented repeatedly and expressly they do not seek to hold the company individually liable for the damages. What should we make of the reality the company counters? The plaintiff seeks putative damages. It is true that putative damages are not available against counties. It's true in some instances, courts have repeatedly treated a request for punitive damages as indication a suit seeks individual liability. But none of this alters the equation given the plaintiff's express representations that the company faces no liability. Even so, the company asks, what should we make of a second reality? The plaintiffs have amended their complaint twice and have yet to clarify the company does not face money damages. That is true. Well, it does not alter what they have clarified. In 4 separate filings, they insist they do not seek damages from the company. Judicial estoppel will prohibit any change of heart now. So, among other things, we're looking at different things in different filings. And so the company is saying, well, look, they never amended their original complaint to take us out of it. Well, it's like, well, that's true. But they said in 4 other filings that it's true. So even though they haven't changed it in their original pleading, they have created an estoppel, which is, to prevent them from changing. They've already made representations and we're going to stick with it. And this may or may not be comparable to the issue in the Vic Mignogna case, because to the degree to which certain representations were made and those were defied upon, you can't then look to other things. It's like, it's an issue of estoppel. It's once you make representations to a court, they're binding. So, you have to look to the whole picture. I feel like, cut this part out, but I feel like every case I should just analogize to the Vic Mignogna case, because then I'll get more clicks. On the record. Now consider McNair. She seeks qualified immunity on all the 1983 damages claims brought against her. In response, plaintiffs represent they have not asserted any 1983 claims against McNair. There is good reason to take their word for it. Our review of the complaint confirms as much. Not a single claim against McNair appears in it. McNair worries that 2 features of the complaint cast doubt on the conclusion. She points out the complaint she's being sued in her individual and official capacities, but that language alone does not create a 1983 claim, especially in face of the plaintiff's disavowal of such a claim. All in all, the plaintiffs have not filed individual capacity 1983 claims against the company or McNair. No qualified immunity defense thus applies to them. So we're seeing some problems in the pleading. We're seeing some problems in the way it was argued. It's like, you don't even have to raise these arguments. There's nothing here for you to raise arguments against. So it's like, you don't need to raise a defense because you were never implicated in the first place. Okay, it sounds like some problems in the drafting to me. The company argues that if any claims targets its official capacity, sovereign immunity bars claims for monetary relief. Sovereign immunity, however, protects states, not counties. The question is that whether the company acts for the state or the county. The key consideration, who pays a judgment, predominates. In this instance, no one claims the state as opposed to county would pay any judgment. That puts the company in the hole to start, and things do not improve from there. Another consideration is who handles the misdemeanor probation in Tennessee. The state statute assigns responsibility to misdemeanor probation to counties. That suggests the counties would pay any judgment. So there's no sovereign immunity here, because even if you're the government, you're the wrong kind of government. So that's fair. All factors considered, Tennessee private prohibition companies do not act for the state and thus may not invoke Tennessee's sovereign immunity in the lawsuit. Reinforcing this conclusion is more of a concrete reality. We know of no case in which a private probation company has successfully invoked sovereign immunity. That leaves a few ends. The company and McNair devote 2 sentences to arguing their entitlement to witness immunity, and they dedicate a single paragraph, mostly block quotation, to quasi-judicial immunity. But they do not explain which claims these immunities were foreclosed or why they would apply. Both arguments are foreclosed due to insufficient development, and we affirm. So that is the end of our coverage of this case. In this case, we learned that Community Probation Services was sued for various things, but they weren't sued very well. The complaint was not well done. And so the company says, oh, we have responsibility. And the court's like, no, you don't, because they failed to really do anything in their complaint. They failed to allege against you. They made all these disclaimers on the record. There's no problem. So, none of this applies to you. So, it's good for the parole services, I guess, but not so great for the person who drafted the original complaint, because apparently they failed to such a degree that, basically there's no complaint at all. So that is the end of the coverage of this case. Hello, everyone. My name is Kurtzu, and I am a wafu, and I want to talk to you about law. Needs work. Needs work. Needs work. Needs work. I also accept super chats to do singing because people love my singing. All right, let's see what we got. Two more. Let's do the 1983. Let's do the Title IX complaint first, whenever. Let's do the Title IX one. Hello, everyone, and welcome to Uncivil Law. For today's case, we have a Title IX issue coming out of a college. This is Rebecca Forrester versus the Board of Regents of the University of Michigan. In this case, Ms. Forrester was being subject to unwanted treatment from a fellow classmate to a degree that potentially interfered with her ability to get an education. She is suing on the basis that the university did not do enough to protect her. And so the Court of Appeals is trying to determine the degree to which the university might be liable for the actions it took, and perhaps even more importantly, failed to take as it relates to this situation. So let's look at this. Who's the respondent anyway? Allison David Blake? Allison Davis Blake? Allison apparently is a guy's name. Allison is apparently a guy's name. Who knew? Okay. Has anyone ever known a guy named Allison? Apparently, Allison is a guy's name. I'm curious. Okay. Foster and another student were both part of an off-site executive MBA program based in Los Angeles through the University of Michigan School of Business. As part of the program, the students occasionally took part in residences, which were once a month weekend educational sessions at the Beverly Wilshire Hotel in Beverly Hills. Nice venue. The students would check into the hotel on Thursday night, take part in all-day sessions on Friday and Saturday, and check out on Saturday night. Foster developed a friendship with the respondent in fall of 2012 through the spring of 2013. She did not have a dating or sexual relationship with respondent. Respondent began sending her complimentary texts to Foster and began expressing a more intense romantic interest in her. At this time, he began giving her unsolicited gifts, informing her that she held beguiling power over him, and suggested he wished to date or marry her. Okay, that's a lot, but all right. In addition to the unwanted physical contact between September 2013 and February 2014, the respondent repeatedly expressed romantic feelings for Foster, despite her clearly rejecting his advances and informing him that she wanted a platonic friendship. On February the 28th of 2014, after receiving a series of messages from respondent regarding his perception of their failed relationship, Foster called respondent, told him he should seek professional help, and asked her not to call her about romantic interest in her anymore. After the respondent sent Forrester several text messages on the 9th and 10th, to which she did not respond, the respondent sent her a text message on the 11th saying, "Do I creep you out?" Forrester responded, "No, you're scaring me and I want this to stop." The two exchanged several messages thereafter, with Forrester accusing him of trivializing the way she felt. This sounds like a guy who does not have the ability to take no for an answer. And it's like, this is, yeah. In March of 2014, Foster reported the incident of sexual harassment to the University Office of Institutional Equality. Over the next few days, them and the Title IX coordinators from the university were in touch with Foster to interview her and collect documentation corroborating the report. What corroboration was there? I'm glad you asked. On March 18, 2014, Foster provided them with 300 screenshots and 900 text messages the respondent had sent to her and evidence of gifts and letters she received from him. I'm not 100% sure I've sent 900 text messages to anyone. That's a lot of text messages, man. Yeah. She also raised concerns about online sessions taking place the next day. Specifically, she did not want them to respond to know that she'd be attending. On March 21st, 2014, the Vettingler contacted respondents, scheduled a meeting to discuss the Foster's allegations. In a subsequent email that day, they finalized plans for the meeting and stated, "In the meantime, you're instructed to have no contact with this other student. This includes direct and indirect contact. It includes contact in person, by email, by text message, by phone, or through a third party. In addition, as you read the student sexual misconduct policy, the university prohibits retaliation of any kind, so you're instructed not to retaliate in any way." When it began to investigate the complaint, the university developed a set of interim accommodations in response to concerns. One accommodation the administrator discussed internally was where respondent would stay and eat during the upcoming residency. On Saturday, March 29th at 11:45, respondent sent text message to Forrester that stated, "Really?" That next same night, Forrester notified Vellinger of that message, saying it was very disturbing and asking, "Should I make further arrangements for my safety at this point?" The next morning, Vellinger responded, "I will address this text with the respondent tomorrow. As to your safety, you are the best judge of your immediate needs. Please keep me informed if he makes any other contact." On March the 31st, Claire Heinger, managing director of the program, sent Forrester and respondent separate emails enumerating a list of accommodations for the residency, which would begin in a few days. Hogiyan also stated she would be present during the residency to ensure compliance. Foster was unsatisfied with the accommodations. In correspondence that day, Foster stated the accommodations do not address my safety, and she did not want to be in the same room as respondent during the upcoming residency. She reiterated that respondent had violated the no contact order with his March 29th text message, and here I'd point out that by no contact order, we're referring to what the school did. So this is not a no contact order from a government, which, incidentally, is one of my broader criticisms of Title IX in general. If this is a problem, why not just go to a judge? Is that not an option? If not, why not? Judges do no contact orders all the time, and they do them on an emergency basis, for exactly this reason. So why is the normal system, if anywhere else in the world someone has a problem with someone else, then they go to a judge for a no contact order, right? That's what you'd normally do. So why not do that here? Why not go to a judge and get a no contact order? It looks like you have enough evidence. You have 300 screenshots and 900 messages and proof of evidence and proof of all the rest of it. So I'd imagine a judge would issue a no contact order, and then it'd be issued by an actual government authority, a judge, who then the police could enforce. And then also the university, being also government actors, because they're a public university, right? Them also would have to give full faith and credit to the judge's decision. So why not just go to a judge and get them to do it? I mean, putting aside whether the university could or should have done more, it's a little unclear to me why don't we just go get a judge and get them to do that? This is one of the things judges do. This is not their first rodeo. So they would have a better idea of how to evaluate the evidence and all the rest of it. So not quite understanding that personal component myself. And violating a judicial no contact order obviously has massively bigger ramifications than violating a request from some Title IX coordinator. Not quite the same category of defiance. Foster also inquired how she was expected to handle class participation, how to manage breaks during class sessions, given that, for example, she'd have to cross paths, and how the university would address desire not to see him and for not to see her, including a social function, and whether the respondent was able to discuss with others in the investigation why accommodations had changed. Later that night, respondent sent a crude email to various university administrators. He referred to the Title IX investigations as a witch hunt and specious, nice word choice, and referred to Foster as your psycho ho beast client. Never heard that one, nice. And lying slut whore. He also stated that if you think for a minute I'm either going to miss an upcoming social activity or abruptly depart just because of some lying woman who seeks baseless, vindictive retribution, you've got an inflated sense of your own influence, and with that, another thing coming. Do we not believe in capitalization or spelling? We are a student, right? I recommend you protecting your shrinking violet client by informing her and in fact be there. If she or you have a problem with that, you're welcome to pound sand. Again, this will be a kind of reason why, at least to me, one of the questions I'm asking is, among other things, why not go to a court? Why not get an actual no contact order from an actual judge who can actually enforce it with actual laws? That's a good question. This guy saying to a random administrator, I'm not going to obey your no contact order, is not quite the same as I'm going to disobey this judge's no contact order. One carries significantly broader ramifications than the other. So among whatever other relief, why not go to a judge and get them to issue an order? Judges do this. It's one of the things they do. Stephen Bartles asks me, does Title IX prohibit using a judge, and does she have to go to a judge? No, Title IX gives her an additional claim of relief. It doesn't foreclose other relief. So Title IX gives her a right that can be enforced. Also, it's a statute and can be enforced by a judge, too. So Title IX gives her a claim to sue or to ask for emergency relief, for emergency petition. So it gives her a basis, too. So Title IX gives her some ability to impose on the university, but Title IX, as well as just like general law in general, dealing with harassment and unwelcomed things, would give you Title II there. So why not go to a judge and get them to issue an actual order? Or why does the university go to an actual judge and get them to issue an actual order? If it's that bad, if it's this big of an emergency, if there's apparent actual threats, why not go to a judge and get them to issue an actual order that has actual binding authority? So I know of no reason you can't get both. According to Foster, in subsequent conversations, Foster learned on Friday morning Vellinger and Anthony Wallersby, a Title IX investigator, had told them to remove respondent from the property, but Hollinger kept him in the classroom because she believed there were no imminent danger and thought removing him would escalate the situation. Okay, well, different levels of government are arguing about like the best thing to do. Okay, I'm not sure whose call this is. I'm not even sure it's necessarily the wrong call. But again, if we went to a judge, we could solve many of these problems. Foster claims that during classroom breaks on Friday, April the 4th, the respondent violated their interim accommodation in numerous ways. He stood in front of her, of an exiting classroom, which probably qualifies as kidnapping under the letter of the law. Second, he stood in front of a beverage table during direction of the break, preventing Foster from getting coffee. And third, while Foster was away from the desk, the respondent stood near or sat on her desk while speaking to the professor, preventing her from returning. Later that day, respondent was in the lunchroom, which prevented Foster from getting lunch. Professor Metha asked Foster if she needed help, and Foster responded, "What is happening here? None of the interim measures are being held out." It's a bit of a problem. Foster testified that she had to be very discreet in this conversation because she's sitting next to two students, and they're wondering why they could not enter school. Oh, Matt. Oh, Matt. Matt. You didn't learn. We had this discussion already. We had this discussion when we reviewed your bar exam answers. Remember? We had this discussion about the difference between criminal law and civil law. So I said kidnapping. You say sounds like more false imprisonment rather than kidnapping. But one of those is civil and one of those is criminal, Matt. Did you confuse your civil and criminal again, Matt? Did you confuse your civil and criminal law? These are two different things, Matt. And it can be both at the same time. Don't stop conflating criminal and civil law. You'll do better on your bar exam answers, Matt. And kidnapping is the criminal charge, Matt. Kidnapping is the criminal charge. False imprisonment is the civil charge. So if you're saying it sounds more like false imprisonment, and you're saying it sounds criminal, you are saying two entirely different things. You can't say both of those at the same time. Kidnapping is the criminal. False imprisonment is the civil. Try again, Matt. Try again. No, don't go away because you'll learn things. You'll learn things. Yes, kidnapping is the criminal charge. False imprisonment is the civil charge. Don't confuse one for the other, Matt. You'll do better on your bar exam. Ah, man. We love you, Matt. You're great. That evening, respondent attended a karaoke event he referenced in his late email. Foster did not attend. Late in the evening, however, she notified that the respondent had posted to the wall, calling her a scrub and making a threatening comment about the boyfriend. On Saturday morning, April the 5th, Hogan called the Hyatt Regency Hotel, where respondents saying asked security to go to the room and inform him that he's not to report to class for the day. Shortly thereafter, the respondent spoke with them, who informed him that he had violated the no contact order, again issued by random administrator rather than judge, which carries, again, different things. I don't want no scrubs. Very good. Very good, Courtney. Shortly thereafter, respondent spoke with Hogan, who informed him they had violated the no contact order, and therefore he is disallowed from attending class and should not come to the class that day. The respondent did not attend class. He did, however, write an email to several classmates with the subject line explaining my regrettable absence today, in which he provided background on the investigation. Stated because he violated no contact order, he's barred from attending class. This email included the following statements. Good. I engaged in an inappropriate relationship with our classmate, Rebecca Forrester. This guy is fun, yeah. Her claim is false, baseless, and vindictive. She is a mean, awful person, a wackadoo chick. My, what a time we had in bed and mine for a few months there. Woof. This guy is special, man. I have no malice for her. I can just tell the lack of malice. The lack of malice is dripping off the page. Lord have mercy. I have no malice for her, and shall be ever grateful for the day, ever grateful for her sharing those world class tots with me for a while. Oh man. Oh Lord have mercy. This guy. I am by no means an expert on domestic violence law by any stretch. I am by no means an expert on like the things that might do red flags or subtle signs or things like that. However, I'm a reasonably well-educated guy. I know things in general a lot, and at least to my very uneducated mind as to the specific domain, these statements strike me as red flags. These statements strike me as a guy who does not have it all together. This strikes me as a person who is an imminent threat to himself and others. This strikes me as a problem. Now, again, I'm not an expert in this domain. I'm not an expert in this domain, so maybe to an expert, this sounds perfectly fine. However, to me, as a layperson, I'm looking at this and like, we've got a problem here. We've got a problem. That's what strikes me. Don't know if I'm alone on that one. Don't know if an expert would disagree with me, but to me, it's like, this is not good. We should do something about this. Wow. On April the 29th, Foster informed Hoegan that she and Lorman respondent would be traveling to Ann Arbor for commencement through Facebook and conversation with 2 other students. Foster informed Hoegan that she had a restraining order in place, but believed it only pertained to Los Angeles. Hold on, we missed something. Aha. I apologize. We missed the line. We missed the line there, so we have to go back. Let's read that other line. Okay. On April 17th, Foster obtained a restraining order against respondent in Los Angeles. Okay, so finally, we have done the thing we probably should have done much earlier in this process. Someone somewhere should have done this probably much earlier. But finally, Foster went to an actual judge and got an actual restraining order that has actual force of law to it. You know, it sounds like something that probably should have happened earlier. Make no mistake here, I'm not blaming Forrester. I'm not blaming her. She thought the university was there to protect her, which apparently it wasn't, which is amazing given the Title IX cases we've seen. It seems like more often than not, the university will bend over backwards to give very dubious allegations full force and conduct, witch hunt, Star Chamber-like proceedings. This doesn't strike me as one of those situations, however. This kind of strikes me as the opposite. So, I don't blame her for going to her university. I do blame the university for not saying, I do blame, not this. But finally, someone took a hint and actually went to an actual judge and got an actual restraining order that has actual force of law. Yay. Thus, we will read that other sentence now that we know that there is an actual restraining order that actually exists from an actual judge with actual force of law. Okay. Then, on October 29th, Foster informed that she had respondent would be traveling to Ann Arbor with 2 students. Foster also informed Hoegan that she had a restraining order in place, but she believed it only pertained to Los Angeles County. Okay. And then I'll read the rest of this too. Hoegan testified that until it became clear respondent would be traveling, we were up until that point operating under the hope. Wow, geez, that sounds real promising. We're operating under hope. In light of this situation, geez, oh Lord, we're operating under the hope, if you will, that he'll follow his attorney's advice or direction and not come. I'm not sure going on a wing and a prayer was necessarily the best course of action in this situation. Once Foster informed the university of respondent's post announcing his intention to attend, administrators had the emergency get-together in which they put into action a preparatory plan. Or, you could just look at the restraining order and see what it says. Because, it probably is relevant here. On the night of April 29, 2014, Forrest was in a common lounge area of the executive residence for the graduation gathering, which she saw respondent through a reflection in the glass in the same room as her. This just gets creepier and creepier with every passing moment. This guy has problems, man. This guy has problems. I don't know what they are, and I have a little bit of sympathy for him, but I have way more sympathy for her because he is a danger. I don't know what's going on in his head, but Lord. He stood up and looked at her. She went downstairs to the lobby of the hotel where she was put in charge with Sergeant Hicks, the plainclothes officer stationed at the executive residence in case the respondent appears. So there was actually a police officer there, thank God. Hicks and another officer told respondent to leave the executive residence. The next day, Forrest provided the university with a copy of the restraining order, and after it was determined the order extended to Michigan, because of course it did, because the way these things are ordered, they are general, right? Because the court that issued this has relevant jurisdiction. Everywhere. It's a court of competent jurisdiction. And, when we're talking about nationwide injunctions, we're only talking about, in this case, one person, right? As opposed to broader issues. So a court in LA is issuing an injunction, which probably says something along the lines of, you must stay 500 feet or whatever away from this person, blah, 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 etc. And it applies everywhere. It applies in all the places. Because of course it does. They provided him a copy, and that was determined the order extended to Michigan, presumably by, reading it. Law enforcement officers arrested the respondent. He was released in the custody of the University Police Department and transported to an airport to board a flight back to California. Okay. So now we're finally going to get to the Title IX cause of action. So now we're finally getting to all that. We're now going to sue the university for their power. So, for failure to do stuff. So the court's ability to do stuff was apparently much wider than the university's is for some reason. So Forrest brought this action under Title IX. The court explained that as a result of the university's promptly, compassionately... Okay, okay, wow. The district court granted the motion for summary judgment to the university. The court explained that as a result of the university providing prompt, compassionate, and effective relief, the respondent's text messages to Forrester, his Facebook messages messaging her, and physical interaction were all but stopped. I don't know, district court. I don't know, man. I mean, at least, well, I don't know. I mean, I am reading the relaying of the case as decided by the Court of Appeals that outranks you. So the Court of Appeals apparently disagrees with your assessment of the case. I've been reading the Court of Appeals decision for a little bit now, and at least based on my reading of the Court of Appeals decision, I think it would be a little much to say the interaction had all but stopped. Unless we have a very, very, very loose definition of all but stopped. If by all but stopped we meant continue going exactly as it had before, then sure. But other than that, the Court of Appeals doesn't seem to be having any of it. So, not sure what you were looking at, District Court, but holy Lord. So now we have to get into the Title IX standard. Is the university liable for any of this stuff? Oof. In Davis versus Monroe, Supreme Court held Title IX may support a claim against a recipient of federal funding for student-on-student sexual harassment. All right, so to answer someone's earlier question about, why is this covered by Title IX, because where's the discrimination on the basis of sex? Here's the answer to the question from earlier in the chat. Here's the question, the answer. Why is this Title IX? Well, here's your answer. In Davis versus Monroe County, the Supreme Court held Title IX may support a claim against a receipt of federal funding for student-on-student sexual harassment. The Supreme Court said so. There you go. There's your answer. That was easy. When they can show that the sexual harassment was so severe, pervasive, and objectively offensive, it could be said to deprive plaintiff of access to an educational opportunity, that the funding recipient had actual knowledge of sexual harassment, and the funding recipient was deliberately indifferent. Only on the third prong, the one most relevant here, a plaintiff may show deliberate indifference, where a respondent's response to harassment or lack thereof is clearly unreasonable in the light of known circumstances. The deliberate indifference at a minimum causes a student to undergo harassment or make them likable or liable or vulnerable. A school need not engage in particular disciplinary action to avoid liability, but where a school district has actual knowledge that efforts to remediate are ineffective and continues to use the same methods, the school has acted with deliberate indifference. Matt, you have to stop asking me really insane hypotheticals about embassies, Matt. I don't know, but presumably yes, even in embassies, because it's an order against you personally. And at least as to U.S. law, I don't know if this is a uniquely U.S. law thing, but it is well established. It is well established as a matter of U.S. law that the U.S. law can continue to bind you as a U.S. American anywhere in the world. All the places in the world. So one of the things that, for example, exists is a law dealing with trafficking, sex trafficking as it relates to minors. And it, among other things, makes it illegal for a person in the United States to visit a foreign country for the purposes of engaging in sex tourism. And you might say to yourself, wait a second, this happened fully within the bounds of another country, subject to their laws. And the courts say, aha, but you're a U.S. citizen. And that means the U.S. government gets to control you everywhere. All the places. So yes, I assume this restraining order would apply in an embassy, in Antarctica, on a space station, and all the other places. Because U.S. law gets to touch you everywhere. All the places. So, it's one of the perks/drawbacks of being a citizen of the United States. They have jurisdiction over you everywhere. The Supreme Court has acknowledged that in an appropriate case, there's no reason why courts, on a motion to dismiss for summary judgment or directed verdict, could not identify a response that's not clearly unreasonable as a matter of law. Whether a school belatedly stepped up its efforts were too little too late, however, may be a question for a jury. So yeah, the issue as to whether it was too much or too little too late or stuff sounds like factual based questions, right? Because we're assuming a whole bunch of facts here because we haven't had a trial yet. So we're assuming a whole bunch of facts. But yeah, if we show the right facts, it could be a problem. Again, I don't know that this is a specifically U.S. law aspect. It is. I don't know that it's only the U.S., but if it's not only the U.S., it's one of like one or two other countries. But it is like one of two other countries where the U.S. will charge you tax no matter where you live and no matter where you earned money. So that is a relatively unique U.S. feature. Most countries in the world do not charge you income tax if you're a citizen of that country, but you earned your money overseas. The U.S. does, but most countries don't. But in general, I don't know how weird it is for other countries to bind you to their law as you're traveling around the world. I don't know how unique that is or not. Um, if I had to guess, I'd imagine that there's some laws that in most countries that are similar, but I'd be guessing. I don't know. $5 from Furby Slayer. A Canadian kills American in Mexico. All three countries have a claim on the case that has been to be determined by some court or claim or treaty. Yes, it is quite possible. It is quite possible that all three countries would have a claim. It is quite possible. Yes, the Mexican government has jurisdiction because the crime occurred in Mexico. The U.S. government has jurisdiction because a U.S. citizen is involved. Um, well, I don't know that the U.S. government has. Well, they might, but probably not the U.S. government because only the victim is American. But the Canadians would because the perpetrator is Canadian. So if a Canadian kills an American in Mexico, then Canadian government has jurisdiction and the Mexican government has jurisdiction, and the U.S. government might, but I'd be less sure about that. It's possible, but I have to look into it more. The university has waived any argument that sexual harassment experienced by Foster was not severe, pervasive, and objectively offensive. As Foster correctly points out in its motion for summary judgment for the district court, the university did not argue that Foster was not the victim of student on student sexual harassment. Seems that way. Indeed, even on appeal, the university does not meaningfully contest Foster's ability to satisfy the requirement. In its brief, the university states, without elaboration or further argument, Foster cannot establish that after the university had actual notice of the harassment, she experienced severe, pervasive, and objectively offensive behavior that deprived her of access to educational opportunities. Really, though? Oh yeah, no, we can throw in some fun stuff too. So we can make this happen on a boat that is flagged of a different country in the economic waters of a different country. We could get some interesting hypotheticals going on here. If we really want to stretch the bounds and stuff. So yeah, but yeah, that could definitely be a thing. Yeah, yeah. It happened on an aircraft carrier that's flagged under one country, and for reasons that pass understanding, it also happened inside an aircraft that is flagged of a different country, even though it's on an aircraft carrier. Don't worry about it. Which is in the seas of another country, which is of this country, and involves citizens of we could get crazy on all kinds of hypotheticals. It could get weird. Yeah, let's just throw in some pirates while we're at it too, just for the heck of it. That'll be good. The only subsequent reference to the issue is a footnote in which the university claims because of any interactions between Foster and the respondent during commencement weekend did not constitute a severe, pervasive, and objectively offensive sexual harassment. Foster's failure to demonstrate that she was denied access to educational opportunities provides an alternative ground for affirming the district court's opinion. Even if the university had not waived the argument, however, we could not conclude that as a matter of law, Foster fails to demonstrate severe, pervasive, and objectively offensive sexual harassment. In assessing the severity, we look to something more than just juvenile behavior among students, even behavior that's antagonistic, non consensual, and crass. In assessing pervasiveness, we look for multiple instances of harassment. One incident of harassment is not enough. In assessing objective offensiveness, we look to behavior that would be offensive to a reasonable person under the circumstances, not merely offensive to the victim personally or subjectively. Although the causation element of Foster's deliberate indifference claim is limited to the university's actions after Forrest reported the respondent's conduct to the university, as discussed below, the analysis of the severity, pervasiveness, and objective offensiveness of the harassment is not limited to events post-dating. Thus, we must conclude that the full scope of respondent's behavior towards Foster, meaning harassment before and after report, were severe and objectively offensive for the Title IX purposes. Because again, remember, we haven't had trials, so we're assuming things in the light most favorable to the non-moving side. So we assume basically everything Foster says is true. And so that's kind of the position we're in. From his physical misconduct in the winter of 2013 to his disparaging beret of emails to classmates and professors about Forrest in 2014, the response behavior clearly rose to that of actual sexual harassment. The university argues nothing to the contrary. Okay, Matt. Let's make Matt's life as a law student just go completely to shit. Let's make his life completely go to shit in a hypothetical I'm going to create just to make his life a total nightmare. Here's your exam question, Matt. All right. Here's your exam question. All right. We got a person who has joint citizenship of Portugal and Russia, who is located in the United States, who is interacting with a person of joint citizenship from Spain and South Sudan in the United States. And they're on a parcel of land which has some interesting qualities to it, Matt. It has interesting qualities. Would you like to know about these interesting qualities? I'm going to tell you about these interesting qualities, Matt. It's a very, very interesting parcel of land, Matt. This parcel of land has a whole bunch of different claims to it. First of all, we got some federal law claim issues because, of course, this is Native American land. And also, it's of competing tribes. So we got some competing tribes of competing land. Also, did I mention that this land stratifies multiple state lines? Yes, this land is across multiple state lines at the exact same time. And also, on this piece of land that I'm creating, wouldn't you know it? There's some problems with the title map. You know, over the years, this piece of land, which, you know, just so happened to occur on this piece of land, Matt, it's just a total shame. This piece of land has been the subject of some original jurisdiction suits between the states trying to determine where the land boundary is, which has still not really been resolved by the U.S. Supreme Court. And also, incidentally, this piece of land has been the subject of multiple different title issues. You know, there have been people who have been getting title, and there have been people who have sold this land to more than one person. But so they sold it to one person first, but the other person got to the courthouse first to register the land. You know, that kind of thing. And also, you know, there's someone who's put in a quit claim deed, but the quit claim deed seems to have been fraudulently gotten, and that person sold it to someone else, and so we got an issue of estoppel there, Matt. Are you following all this so far? Okay. And then on this piece of land, you know, in this world, you know, we've got issues as it relates to Fourth Amendment issues, because, you know, we're not really sure where this is and stuff like that. And also, incidentally, you know, it's actually the UN. Don't ask why the UN is operating in the United States. Don't ask questions like that. But the UN was the person who conducted the arrest. But it was a U.S. soldier in the UN who conducted the arrest. But they were authorized by law because, I don't know, coronavirus or something. And so they're being arrested. And so I want you to analyze the property interests of everyone involved. I want you to determine who has land of it. Oh, and also, did I mention, by the way, that someone's been sitting on this land for 21 years, although they once went on a vacation for 3 months, and they claim that they own the land because of adverse possession. So I'd like you to determine who owns this wonderful piece of land, what state it's in, what jurisdiction it applies, and what claims, if any, and defenses can be offered by all the people involved. Can you do that for me, Matt? Turn that in for me in 30 minutes. That'd be great. There's your final exam answer. Do that shit for me. Uh, uh, in In Forrest's claim, in Forrest's case, on March 13th, 2014, the university acquired actual knowledge of the month-long campaign of sexual harassment by a respondent against Forrest and implemented a response. The respondent thereafter violated the no-contact order by sending Forrest a text message announcing his indication to violate the order again in an erratic late-night email to the university administrators, tagging Forrest in threatening posts on Facebook, sending retaliatory and harassing emails to Forrest claims and professors after he was barred for the final day of April's residency, and appeared in the same room as Forrest as commenced activities after being prohibited from the attendant commencement. Whether considering the March 13th conduct alone or in full timeline respondent's behavior, it's clear this harassment of Forrest was pervasive. Also, Matt, I didn't actually make clear the actual cause of the actual call of the question. So, this final exam answer I've decided is now being has now been drafted by a sovereign citizen. So here's your actual call of the question. Discuss the implications of this under the UCC. Go. Oh man. Whew. As far as Lawyer Huber goes, that was pretty funny. But yeah. Matt. As a general matter, the university does not deny it has actual knowledge of harassment. Still, for the purpose of assessing whether a jury could conclude the university was deliberately indifferent, 2 points about the university's level and timing of knowledge are worth clarifying. First, on March 18, 2014, Forrest made the university aware of hundreds of text messages respondent had sent to her as an email attachment shown. From the very moment onward, the university had actual knowledge of the pre-report harassment. Matt has given up. That's okay. I don't remember the question, but I did have a Blackacre question on my bar exam. I do remember there was a Blackacre question on my bar exam. I don't remember what it was, but of course there was a Blackacre question. So that was part of what inspired me. Well, I was hoping that you'd go more into sovereign citizen land, and use sovereign citizen logic in your analysis. So because all right, well, whatever. Okay, fine, Matt. Discuss the implications under the Magna Carta. Then go. Good times. The central issue in this case is whether the university was deliberately indifferent to the respondent's harassment of Forrest after he signaled he would not comply. As discussed above, Forrest does not argue the nature or extent of respondent's pre-March 13th conduct toward her should he let the university respond differently at the moment she filed the report. Rather, Forrest frames the issue as whether the university's subsequent actions were adequate and effective once the university was aware that the harasser was not complying with the no-contact order. We first assessed the various actions by respondent and the university responses to them, specifically inquiring whether responses were not, as a matter of law, clearly unreasonable in light of known circumstances, thus demonstrating the school's deliberate indifference to foreseeability, possibility of further action. We then I'm not really feeling the spirit here from Ewim. I'm not really feeling the spirit here. We then assess whether the responses did not, as a matter of law, cause further injury to Forrest, such that the injury attributable is to post knowledge of further harassment, which would not have happened but for clear unreasonableness. In brief, a reasonable jury could conclude the university was deliberately indifferent in responding to the ongoing escalating campaign of harassment. So basically saying that this is just a jury question, and ultimately at the end of the day, it's like who believes what as to what. But it sounds like, this person has a fair amount of evidence of the stuff that happens, and the university doesn't have a whole lot of stuff about what it did. So, not seeing it going completely well for the university. But, it's amazing the university didn't do more because, they usually do. We need a stream of the craziest hypos uncivil law can think of. Yeah. First, Forrest argues that after a respondent texted her on March 29th in violation of no conduct, the university did not take any immediate action and did not make any substantive changes in the conditions, despite her complaints that they did not address her safety. Although the university's email included a robust set of conditions by which the respondent was to abide, Forrest is correct the university did not take any immediate action with respect to the order. In assessing these two incidents, it is true that a reasonable jury could regard the respondent's March 29th text message violation as de minimis, given the message contained only one word and no explicit threat, and could regard April 4th's email as inappropriate yet not violative of the order, given that the email was not addressed to Forrest, and it would only signal respondent's intention to violate the no contact order if certain conditions were satisfied. A juror might therefore regard the university's minimal response as commensurate with a minimal level of harassment. Yet a reasonable jury could also conclude that in light of the extended pattern of sexual harassment, these two incidents manifested a clear intention to subject Forrest to further harassment, warranting a swift and severe response from the university as means of deterring further misconduct. After all, the only evidence before the court of the university's response was the talking to the respondent, which does seem a little insufficient given what we know. In our view, whether the incidents of post-report harassment that befall Forrest were traceable to the university's response is a question for the jury. Although a court may grant summary judgment on an issue of causation when warranted, ordinarily causation is a question to be resolved by the jury. Did the university's minimal response to respondent first violation of the no contact order and crude threatening email lead to subsequent violations, when he tagged her on Facebook, referred to her as a scrub, and threatened her boyfriend? Did the university's response embolden respondent to engage in retaliation against her via derogatory comments about her in emails? The university's failure to institute more severe disciplinary and precautionary measures about the respondent's state intention for Michigan to graduation lead to his appearance in the same room? These are genuine disputes over questions which a jury should answer. We hold a university's responses to foregoing conduct by the respondent may have been clearly unreasonable, despite the fact that the harm suffered was less severe than other cases, and belated responses may ultimately stop certain forms of harassment from continuing. And as a note to my editor, I feel like this story is going a little bit longer than I'd ideally like to. Not for least the reasons we had a lot of diverting stuff. So I'd appreciate it when you're editing this if you trim out a lot of the superfluous stuff, on this particular one, because I don't want to run too long. So that's one of the reasons I was skipping a lot of stuff, because it just seemed like it was going on too long. So, use discretion in keeping some of its stuff in. I'm not telling you to kill all of it, but, let's trim a lot of the excess out of this one, because it just feels like a long story. So that is the end of the current coverage of the case of Rebecca Forrest versus the Board of Regents of the University of Michigan. In this case, we learned that Miss Forrest had a classmate that was treating her in a very disrespectful way. And despite many attempts, it didn't stop. And despite going to the university, it didn't stop. It didn't stop until eventually we got a court order to make it stop. So on this particular one, we try to figure out if the university is responsible. And so to do that, we have to go back to the trial and figure out whether the university had deliberate indifference. That is, was the university doing its best? Were they trying reasonable steps? Or did they just not care one way or another to lead to a Title IX violation? So that's the end of our current coverage. And Railway Hacker, I used to edit this, but then Matt stepped in and started helping me, which saves me so much time. So, thank you, Matt. Well, I definitely edited this before myself. I edited this. How long have you been editing things for me, Matt? Like 3 months, 4 months? Something like that? It's really appreciated, by the way. But yeah. Like October, so 5 months, something like that. Yeah, something like that. It's been very, very helpful. Thank you, Matt. Yeah. Ever plan to return to Ace Attorney? Of course I plan to return to Ace Attorney. It's just always lurking there in the background. Someday to pull it off the shelf. Yeah, it will come back. It will come back. When will it come back? No one knows. But there will come a day when it will stream. So yeah. Hello, everyone, and welcome to Uncivil Law. For today's case, we have an incident with a police shooting under very questionable circumstances, and whether or not the estate, because this person is dead, can get any recovery. This is the case of the estate, a Marquez Smart versus the city of Wichita. In this case, the police shot someone for very weird reasons, it seems. So we're going to read this and figure out whether or not the police can be held responsible or whether or not qualified immunity will protect them from being held accountable. Let's get started with this. In the early morning hours of March the 10th, 2012, as hundreds of people emptied out of bars and concert venues in Wichita's Old Town neighborhood at closing time, Wichita police officer Lee Fronays and Aaron Chafe fatally shot Marquez Smart. The district court grants summary judgment in favor of the officers on the basis of qualified immunity. Reasoning, although the jury could have found the officers had violated the rights to be free, the officers had not violated clearly established law. On the evening of March 9, 2012, Mr. Smart, who is black, attended a concert at Doc Howard's, a large bar and concert venue in the Old Town neighborhood of Wichita, Kansas. According to Latrell James, an acquaintance of Mr. Smart who attended the concert with him that night, she and Mr. Smart left Doc Howard's with a group of people around closing time and all started walking towards the parking garage on Mosley Street. Mr. James was a couple feet away from Mr. Smart and didn't have any trouble seeing him when she heard gunshots. She confirmed the first gunshot wasn't near her group, and Mr. Smart wasn't holding out his arm like he was shooting a gun or anything. After the first shot, Miss James recounted, everyone was running like crazy, and Mr. Smart tried to run down the alleyway that intersected Mosley Street next to the parking garage. Audrius Wilson, a longtime friend of Mr. Smart, who was also with him that night, similarly indicated he never saw a gun other than the officer's hand, did not see anyone other than the officer shoot, and did not know of Mr. Smart ever having a gun. Deshaun Wheaton, a bystander, also testified he never saw anyone except the police shooting and never saw Mr. Smart with a gun in his hand, although Mr. Wheaton admitted he only heard but did not see the first few shots. Two other police officers who witnessed the shooting likewise stated they did not see a gun in Mr. Smart's hand. Officer Froese testified that he arrived in Old Town shortly before closing time, along with several other officers to help with routine crowd control. As hundreds of people started emptying the bars and out of concert venues, which sounds like, typical as might be applicable to like a downtown area, even in Wichita, Kansas, Officer Froese began crossing Motley Street to intervene in a fight involving a large group of people who had heard one extremely loud gunshot from another direction, which could have been anything, presumably. Officer Froese turned and saw a black man with his hand extended with a big black gun in his hand and saw two more shots, and he saw a muzzle flash. He testified the shooter, to whom he identified during the deposition as Mr. Smart, fired two shots towards a big crowd of people in the middle of Mosley Street. Officer Froese stated that he was totally focused on Mr. Smart, who was running in a crouched stance down the side of Mosley Street where the parking garage was loaded. I'm particularly mad now. Officer Chafee, a member of Wichita Police Department gang intelligence team, had also arrived in Old Town shortly before closing time in response to another officer's report of a gun in a parked car. But as crowds started flowing from bars and concert venues and into the street, Officer Chafee began helping with crowd control. Officer Chafee stood on the ledge of an elevated flower. Good job, Dogbert. The Mossberg 500 is a good choice. It's a good choice. I like the Remington a little bit more, but the Mossberg is a very good choice, as I'm sure you will know. Officer Chafee stood on the ledge of an elevated flower bed to look into the crowd and make sure there wasn't a disturbance or anything going on that needed attention. As he recalled, and then, at some point while scanning the area on the west side of the street, I saw a group of people start to scatter, like running towards the south. That caught my eye, and so as I look over, I see people scatter, and I start to hear gunshots, and I see a black male with a yellow shirt standing there with his right arm indexed out at the crowd. Officer Chafee initially estimates he heard 4 to 5 shots. From that time on, Officer Chafee testified he watched Mr. Smart run north along the street and only briefly lost sight of Mr. Smart when he ran behind others in the crowd. Officer Chafee also stated that Mr. Smart was running exactly what Officer Chafee had experienced in the past when people fleeing the police, running fast and crouching low. Well, the missus has reasonably good taste. The Mossberg 500 is a fantastic firearm. According to Adrian Jones of bystanders, about 5 seconds elapsed from the first shot of Officer Chafee followed until the final shots. Sergeant Gulliver, another police officer, witnessed the shooting, estimated 5 seconds elapsed from when he saw until they began firing. Police recovered a .45 caliber handgun, so there presumably was a gun being shot by somebody, with the magazine missing, which is pretty weird, about 10 feet from where Mr. Smart fell. Along the path between the spot where the officers first saw Mr. Smart and the spot where it fell, police found a magazine for the .45 caliber handgun, 2 .45 caliber shell casings, and Mr. Smart's eyeglasses. Forensic analysis specifically linked the 2 shell casings to the handgun. The chief medical examiner who performed the autopsy could not verify that Smart had fired a gun because he found no gunshot residue on the hands. Pretty suspicious. Dr. Christian Westington, an expert for the plan, tested DNA found on approximately 18 samples from the handgun, magazine, and shell casings. 2 of the samples had 2 main contributors to draw. 6 samples excluded Mr. Smart. The remaining samples could not exclude Mr. Smart. Okay. Dr. Wayne Cross, the police medical expert, stated that Mr. Cross was shot 5 times from behind. He further testified that 3 of the bullet wounds exhibited shoring. That is, abrasion on a wound site indicating the skin was rubbing against a firm surface at the time of the exit wound. Based on these shored wounds, Dr. Ross opined that Mr. Smart was on the ground when he suffered 3 shots. Great. The plaintiff also retained a biomechanical expert who concluded that the trajectories of Mr. Smart's gun wounds are not biomechanically consistent with him running in a crouched bound over position. So whatever the police perceived was apparently not reality. Yeah. Yeah, I'm glad I sent you on the sovereign citizen path, Matt. That's good news. Glad I sent you on the sovereign citizen path. That's promising. Matt to become sovereign citizen. Good. Mr. Smart's estate and heirs sued the officers for excessive force. The plaintiff also advanced claims for negligence and wrongful death. The courts determined that taking disputed facts in the light most favorable, they violated the right to be free from unreasonable deadly force. Nonetheless, the court concluded the plaintiff had not satisfied the onerous standard of showing that they violated clearly established law. K.H. Ron, you didn't have to make that particularly clear to Matt as he went down the rabbit hole. You have to make that particularly clear. No, we're trying to, whatever. So now we have to discuss qualified immunity and whether it applies in this situation. The doctrine of qualified immunity shields officials from civil liability so long as their conduct does not violate clearly established law. When a 1983 defendant asserts qualified immunity, the affirmative defense creates a presumption that there's an immunity. To overcome the presumption, the plaintiff bears the burden of showing the officer's alleged conduct violated a constitutional right and the right was clearly established at the time of violation such that every reasonable officer would have understood the conduct constituted a violation. This requirement is satisfied where, at the time of conduct in question, there existed a Supreme Court or 10th Circuit decision on point, or the weight of clearly established authority from other courts found the law to be as plaintiff maintains. Adopting our summary judgment standard to the question, we will affirm the district courts unless the plaintiff can show a reasonable jury could find facts in supporting of the constitutional right which was clearly established at the time. My throat is beginning to give out big time. And my energy levels as well. The plaintiff alleged officer Frost and Chafee violated Mr. Smart's right in three ways: by shooting an unarmed man, failing to warn, and shooting after it became clear he no longer posed a threat. We'll address these each in turn. The plaintiffs first argued the officers violated clearly established law by shooting him, despite the fact that he was unarmed and posed no threat. We conclude a reasonable jury could find the officers violated constitutional rights, but ultimately conclude that this right was not clearly established at the time. Here, the plaintiff's forensic evidence, the multiple eyewitnesses who did not see him holding a gun, and testimony from Mr. Smart's longtime friend that Mr. Smart never owned a gun or carried a gun, all tend to discredit the police officer's story at least as strongly as in a prior case, which would create a dispute of fact as to whether Mr. Smart had a gun. We therefore must assume that for the purposes of summary judgment, he was unarmed because we take it in the light most favorable. Importantly, however, the assumption that Mr. Smart was unarmed does not resolve the issue as to whether it violated a clearly established right. The salient question is whether the officer's mistaken perception was reasonable. Yeah, you won't get a lot of fight on the QI needs help issue. An officer may be found to have acted reasonably even if he has a mistaken belief as to facts established in the exigent circumstance. The protection of qualified immunity applies regardless of whether the government official's error is mistake of law, mistake of fact, or mistake based on basic questions of law or fact. So you or I might get a break on mistake of fact. You or I are very unlikely to get a break on mistake of law. But for the police, mistake of law is totally okay for some reason. Not sure why, but okay. We have held the framework allows deadly force where a reasonable officer would have probable cause to believe there was a threat of serious physical harm to themselves or others. Considering all evidence in the light most favorable to plaintiff, the jury could conclude officers unreasonably concluded that he was an active shooter. The jury could conclude they violated the right to be free from excessive force. To rebut the presumption of qualified immunity, however, which is always the catch, right, Mr. Smart must also establish that this right was clearly established. The state of the law in 2012 did not provide fair notice to the officers. Let's try that again. The state of the law did not provide fair warning to officers that it was unconstitutional for them to open fire on a fleeing person that they believed was armed in what they believed to be an active shooter situation. On this prong of the analysis, we assume Mr. Smart was unarmed and the officers were unreasonable to think otherwise. We nevertheless conclude that their decision to open fire did not violate clearly established rights. Next, the court turns to whether the failure to warn was an issue. The plaintiffs argued that officers failed to warn before shooting. Even so, no clearly established law requires such a warning in this situation. The Supreme Court has held that where feasible, some warning must be given before an officer may constitutionally use deadly force against a suspect threatening to inflict harm. The Supreme Court and this court have constantly qualified this remark as applying only where feasible or practical. Because no relevant authority required the officers to give warning under these circumstances, even assuming the officers failed to warn, we cannot conclude it violated clearly established law. So even the failure to warn was not a problem, and next we must choose to turn to the issue of whether shooting him as he was helpless was a problem. Finally, plaintiffs argue a reasonable jury could find the officer violate clearly established law by Finally, the plaintiffs argue a reasonable juror could find that Officer Chafee violated clearly established law by shooting Mr. Smart after it became clear he posed no threat. We agree and therefore reverse the district court's grant of summary judgment on this point with respect to Officer Chafee. So, we had begun to lose hope here that this officer was going to get away scot-free. But, with when you're completely helpless and still being shot, apparently that is enough. So we do get to go back to trial for something. So there's that. Taking the facts in the light most favorable to the plaintiff, a reasonable jury could conclude the officer shot Mr. Smart after it became clear Mr. Smart no longer posed a threat. Mr. Whedon described Mr. Smart as lying on the ground with arms stretched out, looking back, shaking his head like he had given up. The plaintiff's biomechanical expert opined Mr. Smart's bullet wound could not have been inflicted while he was hunched forward, as they described him while fleeing. Also, the plaintiff's medical expert explained Mr. Smart's 3 shored bullet wounds indicated he had been shot 3 times in the back, while on the ground. 3 times in the back while on the ground. From this evidence, a reasonable jury could conclude that by the time they filed the final shots, Mr. Smart was lying face down on the ground with his arms outstretched, unarmed, and had time to look back and shake his head. A reasonable jury could also conclude, based on witness testimony, that at the time to receive Mr. Smart no longer posed a threat, and the officer likewise has the opportunity to perceive the threat had passed before the final shots. So apparently, there is no qualified immunity if you shoot a person 3 times when they're lying on your back on the ground. So, there's hope. The plaintiffs point to several circumstances that, if true, could have put the officer on notice that Mr. Smart posed no threat. Mr. Smart fell to the ground, had his arms outstretched with his empty hands visible, looked back at it, and he shook his head. And another eyewitness who, like the officer, was in the midst of a chaotic situation, had time to perceive did not pose a threat. Therefore, a reasonable jury could conclude that Officer Chaffee violated Mr. Smart's right to be free from excessive force by firing the final shots at Mr. Smart after Officer Chaffee had enough time to recognize and react to the fact that he no longer posed a threat, even if he ever did pose a threat in the first place. Turning now to the second prong of qualified immunity, is clearly established that officers may not continue to use force against a suspect who is effectively subdued. I'm definitely getting tired, beginning to slur my words a little bit. It's just from tiredness because I'm talking for 3.5 hours. Do we have one more case after this, or is this our last one? This is our last one, thank God. If Officer Chaffee shot Mr. Smart, even though in retrospect Mr. Smart no longer posed a threat, a jury still might conclude Officer Chaffee acted reasonably. There might not be enough time for Officer Chaffee to safely conclude that he posed no threat. But the evidence here, taken in the light most favorable to plaintiff, would also allow a reasonable jury to conclude that Officer Chaffee should have reacted to the changed circumstance and stopped shooting. Because this version of events would have violated a clearly established law, the district court erred in granting summary judgment as to the officer's final shots. For the foregoing reasons, we affirm as to the summary judgment as to the first claims, but we reverse as to Officer Chaffee on the last claim, that Officer Chaffee fired the final shots after it would become apparent they are no longer a threat, and we remand. Thus, that is the end of our coverage of the estate of Marquez Smart versus the city of Wichita. In this case, we learned Mr. Smart was leaving a bar at the end of last call one day, and for some reason the police shot him, even though he apparently wasn't shooting anyone, even after he was already on the ground and had his hands exposed and everything. They still shot him 3 times anyway. So the estate can sue for wrongful conduct, and it will have to go to a jury to determine the facts, and that is the end of the coverage of this case. And I officially turned into a pumpkin a little bit ago. So, these daily recording sessions, these weekly recording sessions aren't very popular. $5 in super chats, not very popular. At least we have 32 people watching. That's not so bad. So, I've given up because I'm tired. So, yeah. So, as always, what I will now do immediately is set this stream to unlisted, which means that anyone who has watched this, who is in their history, can still see it. So if you want to watch this later and you've been watching it, all you have to do is go into your history and get it from there, because as soon as I'm done, it's unlisted. So I'll put this into unlisted status, and that's all. So enjoy St. Paddy's Day. I'm tired. Peace out. Bye.